does in fact play into this whole scenario. So these are difficult times. We appreciate all who bear with us, and we know that your time is valuable, but I know you want us to get it right as much as possible. And so that's what we endeavor to do each and every day on your behalf. And with that, I'll start by saying good afternoon. I'm at-large Council Member Anita Bonds, Chairperson of the Committee on Executive Administration and Labor, and the time is officially 2:04 p.m. on Tuesday, the 13th of May, 2025. We are meeting in person and virtually via Zoom to hold a public roundtable on the Board of Elections. The Board of Elections is the independent agency of the government that is responsible for the administration of elections in the District of Columbia. Last September, we conducted a roundtable with the board on their preparations for the 2024 general election. And I want to thank the board for their efforts in the lead up to that election and for the hard work of the employees throughout the election season. I also want to thank election workers that volunteer to serve their community on election day and during the early voting period. They work diligently to ensure that every District of Columbia resident has the opportunity to vote. Today is focused forward on preparations for conducting the Ward 8 special election and various other issues that have been discussed recently in the public domain on the Board of Elections regulations and procedures. Currently, the board is preparing to conduct a special election for the office of council member for Ward 8. The Ward 8 election is planned for Tuesday, the 15th of July, 2025, with early voting to be held from Friday, the 11th of July through Monday, the 14th of July. In preparation for this election, the board has already certified the vacancy, received nomination petitions and challenges to the nominating petitions, and provided preliminary determination of candidate eligibility. The board will be providing final determination of the validity of challenges on Monday, May 19th. And the board oversees the administration of the special election, including preparation of the printing of the ballots and operating vote centers. The board is also responsible for certifying vacancies in the advisory neighborhood commissions. For many DC residents, the ANC commissioner and commissions are the first point of contact with the district government and their most direct advocate. These positions are unpaid, but commissioners work incredibly hard on behalf of DC residents. They represent their community at public hearings and advise the council on important matters of public policy, including public safety, city planning, and other issues that directly impact the neighborhoods. The ANC serves a key role in ensuring district residents are well represented in the government, and it is very important that these positions are not left vacant. Today, we will hear from both the Board of Elections and from the Office of Advisory Neighborhood Commissions about these agencies working together to ensure vacancies are filled. This summer, the board will also oversee two new proposed ballot measures related to the use of RFK site and the district's observance of daylight saving time. My understanding, these matters will be considered at the July Board of Elections meeting to determine if they are proper subject matter for the ballot. Today, we'll hear about how the board oversees proposed ballot measures, including how measures are proposed, the board's role in determining proper subject matter, and rules and regulations governing signature gathering and challenges. All of this is to emphasize that the board's work is preparing for an immediate election cycle, or managing special elections, checking equipment, updating voter rolls, and ensuring their policies are clearly communicated to the public. Also, during today's hearing, I will examine complaints on Board of Elections processes, the public's understanding of the administration of elections, and its impact on public perception, and even the outcome or the results of district elections. With that said, I would like to represent any of my colleagues who have joined me and ask them if they would like to make an opening statement. And I will turn to Councilmember Henderson. Please join us.
Thank you, Councilmember Bonds, for holding this roundtable today, and good afternoon, everyone. I look forward to hearing from the Board of Elections on a variety of issues, especially the preparation for the upcoming July 15th special election in Ward 8. I've recently been at a couple of ANC meetings in Ward 8 where there have been some questions about how the election will be administered in terms of the number of polling locations. Will everybody be mailed a ballot in the same manner as before? There have also been questions in terms of whether or not the Board of Elections has actually received the funding to be able to go ahead and proceed with this. As you mentioned, special elections require a tremendous amount of effort to coordinate, from identifying volunteers and locations to educating the public and preparing the ballots. And so I'm looking forward to hearing how they're approaching this one, because I do believe this is the first special election since we did make some changes to our overall election processes and procedures. I also appreciate that having the opportunity to ask questions to better understand about filling ANC vacancies. Unfortunately, we do have those from time to time. And then finally, look forward to the conversation about initiatives, but in general on circulations of petitions, reviewing petition signatures, challenges, and the rest of the initiative process. I think for everyone to know, we all have to submit signatures in order to get on the ballot, and it is a arduous process to be able to do it and make sure that you're doing it properly. And I know that it can be frustrating if the rules are not clear, or if the rules are changing in the middle of the process. And so I look forward to having that conversation today. Thank you, Councilmember Bonds.
Thank you very much for joining us and for your comments. And so we will move right to our list of public witnesses. And I believe we have with us for panel one, Joe Bishop Henchman, Commissioner Tom Donahue, and I believe Commissioner Robbie Woodland. Okay, and Dominique Jenkins. Dominique is all right. All right, excellent. All right. So Mr. Henchman, we'll start with you when you're ready. Just when you're ready.
Thank you, Chair Bonds and members of the committee. My name is Joe Bishop Henchman. I'm an ANC commissioner in 5F06, which is in Eckington. I'm also an attorney who's been on both sides of the petition challenge process, both as a challenger and as someone defending people from challenges. I try to do it 50-50. I've been aligned with DCBOE. I've been adversarial to DCBOE. So I'm very grateful that you've convened this roundtable, and I'm primarily here to speak about an issue that I know I've pestered you about quite a bit, which is the OANC currently running special elections for ANC vacancies and instead having the DC Board of Elections do it. I've submitted for the record a letter signed by ANC commissioners from all 8 wards. I think it's about 50 or 60 commissioners signed the letter urging that the responsibility for special elections be moved to the DC Board of Elections. And this is for several reasons. Right now, DC Board of Elections manages the candidate declarations and verifications, but then the actual operation of a contested election, and not all elections are contested, but those that are, it becomes the responsibility of the commission, the ANC commission, to hold the election. And it used to be the case, I'm told, that people would apply and the commission itself would vote to choose somebody and that would be it. But we don't do that anymore, probably for very good reasons. We instead have an actual election where all the voters in that district can vote between the contested candidates and choose who their new commissioner will be. Instead of using DCBOE's full-time staff that we pay all year long and the warehouse of equipment that I think you've toured, council member, instead we have the ANC who are all part-time volunteers with the help of OANC, to be fair, but none of us being elections expert, we go and put on an election with a budget of 0. Voters are not notified by mail of these elections, unlike the other elections we hold in the city. Anyone expecting to show up to register same day is disappointed and turned away, and I've seen that happen in a Ward 2 special election that was a 3-way race. The hours of the elections are quixotic because we have to work around commissioner's schedule and the requirement that they be at least 4 hours. So these tend to be on weekends. And the difficulty of getting multiple commissioners with full-time jobs to be there, because there's a requirement in the law that quorum has to be maintained throughout the election. So it's not like we can just do the election. There has to be a quorum of ANC commissioners there to do it. And if someone leaves, does that mean the election is voided? I don't think we've had that problem yet, but it's possible. Ballots and materials are not provided in multiple languages. I think it used to be the case that most of these vacancies, we got like one applicant and it was over. But increasingly, we're seeing interest in election access generally and ANC elections in particular. And in August last year, I watched there was a Ward 2 special election between 3 candidates. And, I think there's some playing with the language in the statute of, oh, this isn't an election, it's a filling vacancy. But what I saw happen that day was an election with campaigners and candidates and signs and all the things that you would see. And, people not getting too close to the polling location and all that. There's a real opportunity to make these less duct tape style affairs. Ideally, DCBOE should be responsible for conducting these elections using their existing staff and resources. That's what the letter from ANC commissioners lays out in much greater detail. I think you raised this question with DCBOE before, and they represented that they would be amenable and kind of willing to work with you to move forward on that. And I look forward to I hope they say the same thing today and we can make progress on this. I think I'll leave it at that and thank you for the opportunity to testify today.
Thank you very much again for your testimony. And as a commissioner once myself, I feel very strongly about this process and how we kind of let it, like you say, sort of flutter around. And I see Mr. Brennan, former commissioner as well. So we're all kind of understanding what this really does. So thank you very much for your testimony. Commissioner Donahue, take your testimony now. Thank you.
Good afternoon, Councilmember Henderson, Chair Barnes. My name is Commissioner Tom Donahue. While I am not representing Advisory Neighborhood Commission 8A in this testimony, I speak as a 13-year resident of the Fairlawn area of Southeast and a newly elected Advisory Neighborhood Commissioner for Single Member District 8A01. The spirit behind the establishment of ANC commissions, as I understand it, is deeply rooted in the principles of grassroots democracy and community empowerment. It is intended to ensure that residents and stakeholders within a specific neighborhood have a direct and meaningful voice in the decisions that significantly affect their quality of life. ANC commissioners are, first and foremost, neighbors who are directly impacted by the same issues facing their constituents. It logically follows that representation by an individual residing outside of the single member district would not serve the best interest of the constituents, as they may lack the embedded understanding of local matters critical to the effective representation. Having been elected as an ANC commissioner for 8A01, a role I undertake with profound seriousness, I believe it is unacceptable for an elected official to hold an office while potentially violating the established residency requirements. Prior to the 2022 election, my then commissioner reportedly relocated and notified the Board of Elections of an address change. The address provided to the Board of Elections appears to have been the property owned by a fellow friend and fellow 8A ANC commissioner with a different single-member district. Based on the observations and documented attempts to serve this commissioner, there's a strong indication that this address was utilized as her official residence for the purpose of maintaining her ANC seat, despite evidence suggesting she did not actually reside there. Specifically, on one occasion, a process server in a sworn statement reported no answer at the address and quoted a neighbor leaving an adjacent property saying no one actually lived there, live at resident, most receive mail or conduct business. This raises serious questions about the validity of the commissioner's dedicated or declared residency. I submitted a formal request to the Board of Elections seeking their intervention and review of this potential residency violation. The Board of Elections responded to the ANC chair, acknowledging my request and suggesting the convening of a special meeting to consider a potential vacancy. However, no such meeting was ever called by the ANC. Consecutively, the commissioner in question completed her full term, and there was no mechanism available to address the serious concern. This situation unfortunately resulted in a candidate who resided within the SMD losing the election to an individual whose eligibility was and remains questionable due to the residency issue. Turning to the matter of recall petitions, I urge this committee to consider changes to the current process. In March of 2022, I initiated a petition to recall my ANC commissioner due to the issues directly related to her official duties, specifically the denial of my access to ANC meetings. In her official response to this recall petition, the commissioner included personal attacks, falsely stating, among other things, that he, quote, is a racist and hates Black women and Muslims, end quote. This response did not address the job-related grounds for the recall outlined in my petition. Instead, it resorted to baseless personal attacks aimed at discrediting me. When I objected to the inclusion of these defamatory statements, the Board of Elections informed me that I was required to either accept the commission's verbiage, or the recall petition process would be halted. Effectively, I was being compelled to disseminate hateful and false accusations about myself to my neighbors, the majority who are Black, while simultaneously seeking their support for the commissioner's removal. This was a calculated tactic to intimidate me and undermine the recall process. During my communication with the Board of Elections, I inquired whether an elected official could include any defamatory statement in their response, even something as egregious as falsely accusing a voter of murder. The response indicated that if I did not approve the official statement, the petition would disappear, quote, disappear, end quote, effectively silencing the voter's right to seek a recall. The current process creates a perverse incentive for elected officials facing recall to engage in personal attacks and intimidation. Knowing that the response will be printed and circulated by the very voters seeking their removal, they can leverage this platform to tarnish the voters' reputation and discourage community support for the recall. Imagine a white resident approaching their predominantly Black neighbors, seeking signatures for the recall of a Black elected official, while the official's response printed on the petition itself accuses the resident of racism and hate. This is precisely the unattainable and unsafe position I was placed in, ultimately hindering my ability to proceed with the recall effort. To safeguard the integrity of our elections and the rights of voters, I believe two critical changes are necessary. Mandatory Board of Elections review of residency violation claims. The Board of Elections must be empowered and mandated to investigate credible claims of residency violations against ANC commissioners. In my case, the ANC itself refused to address my issue, leaving no avenue for accountability. This could potentially be supported by DC Code provisions outlining the qualifications for elected office and the Board of Elections' responsibility in ensuring these qualifications are met. Example Title I, Chapter 10, which deals with elections and ethics. Further research into specific sections regarding candidate qualifications and challenges to candidacy may be relevant. Restrictions on defamatory, irrelevant statements in recall petition response. The Board of Elections should be compelled to not print and disseminate personal attacks or statements unrelated to the official duties that form the basis of the recall petition. This could potentially be supported by DC code provisions related to election integrity, fair election practices, or even general principles of defamatory law, although directly applying defamation law to an official response may be complex. Arguments could be made that that forcing a voter to disseminate defamatory statements undermines the fairness and integrity of the recall process. These changes are critical to ensuring the accountability of our elected officials and protecting the rights of voters to engage in the democratic process without fear or baseless personal attacks and intimidation sanctioned by the very body meant to oversee elections. Thank you for your time and consideration in these important matters. Accompanying my testimony will be supporting documentation, and I request it be made available to the public. Thank you.
Thank you. Thank you very much for your testimony. Next, we'll hear from Commissioner Robbie Woodland. I believe we have your testimony as well. Okay. All right. Okay, press the button. Okay, you're on now.
Yes,
And we'll
ma'am.
take your oral testimony.
Okay, thank you. Thank you, Chairwoman Bonds, and thank you, Councilwoman, for being here today and you guys allowing me to speak. Thank you for the opportunity to testify today. I apologize ahead of time for the lengthy testimony. I think it's imperative that we get everything on the record. My name is Robbie Woodland. I proudly serve as a commissioner for ANC HC06, representing the Congress Heights neighborhoods. And importantly, I'm a lifelong Washington, D.C. born Ward 8 resident. I come before you not just as an elected official, but as a concerned citizen demanding accountability in a matter that strikes at the core of our democracy, the integrity of our elections. I am here to expose a deeply troubling incident that occurred on April 29, 2025, inside the DC Board of Elections, an incident involving board employee, Ms. Maisha Thompson, and fraudulent nominating petitions submitted by candidate Trayon White for the Ward 8 special election. At approximately 4:37 p.m., I submitted 4 formal challenges to Mr. White's nominating petitions in accordance with DC Official Code 1-1001.08. These challenges were timely complete and lawfully executed. However, upon submission, Ms. Thompson, who is not only a board employee but also a Ward 8 resident and Mr. White's former neighbor, violated established procedures by removing the documents from public view and taking them into a private office. This breach of protocol broke the secure chain of custody designed to protect the integrity of election challenges. Ms. Maisha Thompson removed 24 pages from our filing. This action effectively crippled our challenge and denied the people of Ward 8 a fair electoral process. This is election interference, plain and simple. In those 24 pages, if those 24 pages had been reviewed and submitted, Mr. White would have failed to meet the minimum valid signature requirement and would have been rightfully disqualified from the ballot. Instead, a board employee, unilateral and unauthorized conduct directly obstructed a lawful challenge. Ms. Thompson's actions constitute a serious ethical breach and may also rise to the level of criminal misconduct, including obstruction of justice, fraud, and abuse of public office. Her residency in the ward affected by this election, coupled with her handling of sensitive documents tied to a candidate in her own community, presents a clear conflict of interest in violation of DC Code, DC Government Ethics Acts 1-1162.23. Moreover, my concerns are not limited to internal misconduct. I have obtained audio statements from multiple DC residents whose names and signatures appear on Mr. White's petition pages, each of whom categorically denies signing any document. Fraudulent signatures and misrepresentation in the petition process are grounds for immediate disqualification. This is not an isolated issue. My review of the petition documents uncovered several pages containing forged signatures, an extraordinary number of them that points to systemic and coordinated fraud, not clerical error or oversight. These falsified pages account for a significant portion of the submission and clearly show an intent to deceive both the board and the Ward 8 voters. I'm so sorry, I'm tongue-tied. Ooh. I'm so sorry. Even more disturbing, when I attempted to request a hearing and submit a formal complaint on May the 2nd, I was told on record that I would be wasting the board's time. I'm sorry. Board Chair Gary Thomas then made a chilling statement during the May monthly meeting that the board is an independent agency and he is an independent private citizen. He praised the very employee under question, Ms. Thompson, by name. That's not independence, that's insulation from accountability. Given the extent of the misconduct and the overwhelming evidence of fraud, I'm urging the council and the DC Board of Elections to take the following actions: launch an independent investigation into the actions of Maisha Thompson and immediately place her on administrative leave pending the outcome. Refer this matter to the Office of the Inspector General, Office of the Attorney General, and the U.S. Attorney for criminal investigation and prosecution. Conduct a full forensic review of all nominating petitions submitted by Mr. Trayon White and his designated circulators, including but not limited to former Commissioner and Ward 8 Committee Woman Regina Pixley, current ANC Commissioner Cheryl Moore, Patrice Owens, and Trayon White. I'm also asking that Trayon White is removed from the July the 15th special election ballot based on his failure to meet the legal threshold of valid signatures and the document evidence of fraud. Thank you for allowing me to speak.
Thank you very much, Commissioner Whitman, for your testimony. And the last speaker on this panel is Dominique Jenkins. Ms. Jenkins?
Hi, can you hear me?
Yes, we can. Go right
One
ahead.
moment. I'm trying to allow
There
my
you are.
camera.
We see you too. Okay.
Fantastic. Good afternoon. My name is Laniqua Dominique Jenkins, and I appreciate the opportunity to speak. In 2021, I entered the race as a Democrat because I believed in public service and that it should be accessible to anyone with a genuine commitment to community, not just those with political connections. Like many first-time candidates, like myself, I brought the hope and strong belief of democracy. But just 6 months later, I was removed from the ballot, not by voters, but through a procedural challenge to my nominating petitions. My opponents contested a portion of my signatures, an increasingly common tactic that blocks competition before the public can engage. DC requires at-large candidates to submit 2,000 ballot signatures. I submitted 2,049. As a newcomer, I didn't realize how precarious that small margin made me. My signatures were challenged for missing dates, alleged ineligibility, and questions about voter registration. Some objections were valid, others were not. But I had no legal representation. At the time, I was a preschool teacher and a mother of two. I simply couldn't afford a lawyer. I appeared before the Board of Elections on my own, submitted 64 pieces of evidence, and worked to help voters update their records. Still, I was removed. This experience wasn't just disheartening, it was disenfranchising. It silenced my candidacy and, more importantly, the voices of those who supported me. I wasn't removed because of a lack of merit or public support, but because of a process that too often blocks access instead of enabling it. That's why I'm urging the council to consider the following reforms. Legal aid for candidates. No candidate should be forced to navigate a highly technical adversarial process alone. Legal representation should be a right, not a privilege. Electronic petitioning. DC should adapt a secure digital platform that allows voters to sign, verify, and correct petitions in real time, just like we do with taxes or with our license renewals. Clear protocols addressing challenge signatures. Candidates must receive clear, accessible instructions on how to respond to challenge petitions, what corrective actions are permitted, what documents is needed, and the deadlines involved. This clarity is essential to fairness. Modernization to the signature requirements. DC Public Schools removed cursive writing from the curriculum in 2010, yet cursive signatures are still expected for petition fidelity. This disconnect risks excluding young voters from the process and must be addressed. I speak not only for myself, but for every aspiring leader shut out by a system that doesn't reflect our city's values of inclusion and fairness. It's time to modernize and humanize our democracy so it truly serves the people. Thank you for your time and your attention.
Thank you very much for your testimony as well, Ms. Jenkins. I'd like to start by at least discussing some of the issues that have been brought to our attention. Mr. Hinchman, you're very concerned about how the vacancies for ANCs are filled, and you indicated you have a letter that's been signed by a number of commissioners that are in support of the board the Board of Elections conducting the elections. But for some reason, it seems that, and the board has agreed in the past that they would in fact conduct elections to fill vacancies. However, the vacancies continue to be filled through the individual commission process. And I'm wondering, with your letter, have you presented your letter to the board itself?
It's been introduced here before and circulated, and I think originally it was sent to them, but I'm sure they're familiar with
Okay.
it.
Okay. All right.
And I know Mr. Bass from OANC is testifying later, and he might be able to
Yes.
speak to one-on-one discussions with the
Yes.
CUBOE.
I'm just trying to get a sense of whether or not we're at a point where we're going to move ahead with this process. And of course, we'll talk to Mr. Bass, the Office of ANCs, and of course to the board. But I want to sort of document how long we've been waiting to get resolution, so to speak, without pushing it too hard here and not knowing whether or not the board has formally been informed that this is a situation. You're right. We have mentioned it in 2 previous hearings that this is an issue and we'd like resolution on it. So,
I have plenty of copies, happy to give it to
Yeah.
them.
but you have not actually.
I don't think so.
Okay,
Yeah.
so that's what I was concerned with.
You know, and it may all come down to, like a lot of things come down to, is budgets, although the point I make is we're already paying their full-time staff. We already have the equipment, so hopefully it shouldn't be too much of a budgetary reach.
Yes, I hear you. And in fact, the Board of Elections, and that office of the Board of Elections operates 24/7. So they have indicated, in other words, they're there year round. So thank you very much for that. I wanted to clarify that. Mr. Donahue, I wanted to ask you a little more about your testimony. And I guess I'd like to start, if I could, with your point. You want the board to be responsible for reviewing residency violation claims. As far as I know, at this point, the board does not have any, it is not in their mission currently that they have that authority. And I wondered if, as a commissioner, you have talked to other commissioners in Ward 8 or your own commission about their concern about residency and residency requirements. And if you also have prepared a letter or would be preparing a letter addressed to the board to get some feedback from the board on this matter. It is true they're an independent agency, but it's also true that they administer this very important service for everyone.
Thank you, Chair. As a new ANC commissioner, I was elected in November and began in January. However, this has been a matter that's been ongoing for several years. In my opinion, in any sort of election, we want to make sure that the candidate who's running and who is residing in that particular location represents the people that they, are supposed to represent. I don't think that this is I think this is a no-brainer in regards to the fact that we want the right people who are eligible to be running. In conversations with the Board of Elections, it seems to be that while I was objecting to this pretty much the entire term of her of the last 2 years, I was I've gone from department to department of DC regulatory entities to try to find the appropriate entity that would be able to address it. Not only do I feel that she misled the Board of Elections prior to actually running, she actually declared using this particular address as her own, to run for that year, the 2022's election. And again, I do stress the fact that she ran against another candidate who actually did live in and took that right from him because she ultimately won the election. I'm open to working with any entity to see that change be made just in general. I mean, some entity has to take ownership of the roles of our residents and their addresses. And when a properly filed challenge is presented to the Board of Elections with supporting documentation, just not an accusation, there needs to be some sort of entity, whether it's the Board of Elections, which I would assume would be appropriate, needs to be able to hear that challenge and move forward with appropriate actions.
All right, and so are you indicating to us that you have made a formal request to the Board of Elections on this matter?
Specifically, I've made multiple inquiries and requests during the whole process of the 2 years that she was running, indicating that something needed to be done. That's what got the letter. So they issued a letter to our ANC chair, which ultimately was not followed in a special, because there's two, to my understanding, there's two mechanisms that could initiate a challenge. One is through their regular mail, the Board of Elections regular mailings. So if they're sending out mailings and it gets rejected and it comes back to them, that's the only way that they can initiate a challenge on behalf of the Board of Elections, or the process that goes through the ANC Commission. However, if you don't have support from your chair or from the commissioners on the commission, and it doesn't move forward and they don't call the meeting, then where does the voter go from there?
All right, and so the Board of Elections indicated to you that they do have the ability to check an address, and you provided them in writing with information, and they indicated to you that they would follow up on that information?
And they did, and they followed it up by sending 2 letters
Okay.
from them to our commission and to instructing them to host a special meeting. But then it now is in the power of our ANC, and they ultimately ignored that
Right.
advice and directive.
All right, did the board give you any understanding or proof that they reached out to that particular address? Because I think in your earlier testimony, you indicated that the address the property was vacant. And I'm trying to understand if anything has been done about that finding that you, or that claim that you are making.
Right. According to a sworn statement from a process server that was trying to service or process service on the commissioner, he had talked to neighbors who had said that they believe that nobody was living there. I do know that the property is owned by a fellow ANC commissioner and another family member that is on the same commission as the commissioner serves. So we made 7 attempts to reach out to her at that address. Obviously, throughout this entire time, she knew that we were trying to reach her. We even, the process server even went during an ANC meeting where you would think that they would be, at home on their Zoom meeting. And again, without any success of being able to have her service. The indications from the process servers in sworn statements basically say that everyone around, the people that they had talked to, had not seen her living there or coming and going in any fashion.
All right, well, I appreciate that. Would like to, any documentation that you have of information that you shared with the board, and what the board's response was, it would be very helpful to the committee. One of the things I suspect we are focusing on, and that is the procedures. The Board of Elections operates through regulations, and it could very well be it's high time that they have some laws in place so that we can be more uniform in how we make applications. So I'm thankful that you are bringing these issues to us today.
I sit before you today as a commissioner as a direct result of these two. So it's my goal that, through my commission, that I help bring change to this process so that other voters and citizens don't have to go through what I did. So I appreciate any assistance you can offer.
Thank you. Thank you very much for that. And your second point is well taken, and the board will be with us and in a little time, I'll say. I want to say a few hours. I don't want to scare them to death, but we won't take that long. But we'll hear from the board officer soon.
And I can't tell you the effect that the words that were printed, that I was forced to accept to have printed on the petition, have affected me and my business. Those sort of claims, unfounded, never given an example of one instance of her claims, has affected me greatly, profoundly. As a white person, white male living in a predominantly Black community, you can imagine what sort of effect that has had on. Luckily, the constituents voted me into office, and where I can continue to make changes in the process. So I appreciate your time.
All right, thank you very much for that. And Miss Commissioner Woodland, you have presented a little situation here for us, and with multiple parts, and I'm trying to make sure that we kind of understand all that is before us.
Okay.
You're indicating that you challenged a set of petitions that were submitted by a bona fide, intended candidate for the Ward 8 special election.
Yes.
You challenged them by, I guess, making marks or on the petition form that you were given to look at, and then you took those forms to the Board of Elections staffer, who just happened to have been a resident of Ward 8. We live in any of the 8 wards. You acknowledge that. So this person maybe is someone that you knew, and that's how you knew her to be from Ward 8. Okay, you found out later. But in any event, this individual received your forms, and then what was your understanding would be the next step once they received the forms, had the forms physically in their possession, in their hands?
My antennas went up because I'm not I'm not a new commissioner, and I've submitted challenges before. So I knew that something was wrong the moment she took them and dashed off the way that she did. But I let her do it.
So your concern is what happened when the staffer had the petitions that you were challenging, petition forms
Yes,
that you were challenging in their hand, and they did what with the petitions?
she left and went into another office.
Into another office?
Yes.
Okay. All right. Did she make copies of what you had given her, or did you have a copy of what you gave her?
I saw later that she must have made a copy of it because the link that we get when we want to review what was submitted, it has the petitions that we had submitted, and it also has the page that is unstamped.
Okay.
Yes,
All right. I have not been through the challenge process. I haven't
Yes.
challenged, so
it's a lot.
I'm trying to understand it. Okay. All
Yes.
right.
So very plainly, I had to get together with myself included. It was 7 of us that we got together. We broke these petitions down and we all challenged them. And then we put them together to have them submitted. Now, I did have a colleague that I was working with who wanted to submit his portion separately, but he did not include the cover page and the receipt page that needed to go along with that. He wanted to know if Board of Elections would accept it by email. I asked that question once I arrived, but I already had it filled out in my name in case they said no, in which they did, but I already had it filled out and I submitted it to her. So she took it and she walked between the 2 double doors and she went around the corner and she was gone out of sight with the petition.
Okay. All right. And so how many forms did you give to this staffer?
I gave her 4 separate submissions, and that would have been the page 1 through 28. It would have been petitions 1 through 2, petitions 1 through 58, and petitions 1 through 85.
All right. So these are page numbers you're giving us, right?
Yes,
So 1 through 28 is 1, 2, 3, 4 on.
Yes.
Okay, so that's what we're talking about. Okay, so you gave 4 submissions. You submitted them all at the same time to her?
yes,
All right, so she had 4 stacks,
yes,
each with a cover sheet
yes,
that would explain what was there.
yes.
All right. And did you ask for, or do you in the past recall whether or not you've gotten a copy of what you submit?
Well, you get a copy of everything a little later, but generally I would make copies of everything before I even submit. But once they go up they scan them in and they put them up on the link. So once you do the data request for them, you see everyone's that was submitted.
All right, got you.
Mhm.
So the staffer has these 4 sets. These 4 sets are then handled by the staffer
Mhm.
that goes somewhere else. Is this what you have experienced previously when you have
No,
gone through the challenge period?
absolutely not.
What did you
So-
think should be the procedure? That's what I'm trying to understand.
Right. So protocol is once you come in and you let them know that you want to submit your challenges against whomever you are challenging, they sit down with you at the table. They count through every single document that they give you. They take that you give them. They take your receipt and they sign off on it. They give you copies of your receipt. They stamp the date that they were submitted, and then they go and they take them in the back.
All right.
She didn't do that.
Okay, so as soon as she received them, the 4 sets, she took the 4 sets and left the front where you were
Yes,
and sort of, as you say, disappeared for a minute or 2.
yes.
Okay, all right. So we have to ask questions about the procedure.
Yes.
Again, this is probably through regulations. I don't know, but we intend on inquiring about that.
Okay.
So we'll inquire about that.
Mhm.
So that's the first point that you are making to us. And then you said the other gentleman who did that person, that challenger give you petitions to also submit. I'm assuming you submitted yours in public, I mean, in person, right?
Yes, I
Okay.
took them there in person. I
Okay,
got there about, I want to say a little bit, maybe around 4:35, maybe a little bit before, a little after 4:30. It was enough time. No
Okay.
one was rushing as
Okay.
Board of Election employees, Terry Stroud and Marissa is saying that, you know, it was a tough day because so many challenges had been submitted. Barely any challenges had been submitted, Councilwoman.
Okay.
And one of the things that I do find very odd is that Trayon White submitted 173 pages. I turned those pages in at 4:37 p.m. on April the 29th. The very next day, around 1 o'clock or so p.m. is when I started getting notifications that the challenge was not a successful challenge. I didn't understand that portion of it because there were a few people who had submitted challenges before me, and their challenges were less paper. So I couldn't understand if it took us the full 10 days to go through each and every petition. I couldn't understand how in the world they went through those petitions so quickly. I submitted them at the end of the day. Even if I had to have a team of 7. No 1, 2, 3 individuals could have went through those petitions in an hour. I believe that it is a lot of favoritism. If you look at, I gave copies of everything to Mr. Chavez, Mr. Kevin Chavez. I gave
Yes.
copies of everything for you to review. If you look at the petitions, they allow Trayon to put Trayon for Ward 8. That is not supposed to be allowed. That is favoritism. They don't allow us to put any other names up there other than our own.
All right, you're talking about Kevin Chavis in my office?
Yes, I gave him a
Oh.
whole binder, a whole submission, a folder of.
All right, you
of the
did
documents.
this recently?
This morning.
Oh, this morning, okay.
Not too long ago,
All right,
right before we
okay.
started.
All right, and so let's get back to the process, because that's one of the things
Yes.
we want to understand, what the
Mhm.
process is. And if there needs to be modifications to it, we're open to that, but we wanted to understand what you understood to be the process.
Yeah.
Okay, so they disappear, she comes back, the staffer comes back.
No, she don't come back.
She doesn't, so you're left standing at the counter or something?
No, it was another young lady who came back and gave me the receipts.
Okay, and what did the receipts say? Did the receipts indicate the 4 separate groups of
So,
petitions that you said you reviewed? 1 through 28, 1 through 2, 1 through 58, and 1
Mhm.
through 85.
everything was marked as being received and accepted except for one page, the 1 through 58.
the 1 through 58 was not stamped?
It was not stamped.
All right, but everything else was stamped as having received it?
Yes.
Okay, so what was the conclusion that
So then
you
I
were-
asked, how come this page was not stamped? And when I was asking the gentleman Darius there, how come this page wasn't stamped? Miss Maisha Thompson was coming out and she wanted to know what the problem was. And I told her, well, this page is not stamped. And she said, oh, I didn't know that page wasn't stamped. So Darius stamped it, but then he stamped it with the wrong date. It was stamped for April the 20th. And I said, well, no, this is the wrong date. So then he just drew an X over top of it. And I said, no, I need a new stamp. And then he stamped it with the correct date and I asked him to initial it.
Okay, and the correct date was the 29th of April?
Yes, ma'am.
Okay, so you have 4 documents from the Board of Elections
Mhm.
showing that you submitted these pages?
Yes.
Okay, and What's the difficulty?
The difficulty is that Board of Elections contacted me the very next day and said that 24 pages were omitted. And I was a little confused in how they was using the word omit. So I reached back out to Miss Corrente and I asked her, omitted by who? Are you saying that the pages were taken out by Board of Elections, or are you saying that they were never submitted by me? And she said that they were never submitted. I immediately told her that was untrue, and I demanded to know the name of the woman who was assisting me.
I got you. All right.
Mhm.
Okay, well, we have, just so the public knows, we have several petitions before us. So we were wondering if you had these, to be very honest, naturally. And thank you very much for at least,
And if you look at, like I just did some example tabs for you, if you see the little tabs that's poking out, if you flip that up and just take a quick look at it, you'll see that the entire handwriting is all the same. And there are plenty of them in there that way.
all right, well, thank you. I just wanted to make sure we understood the process
Yes, ma'am.
and that the process is one that we want to address.
Yes, ma'am.
Obviously. Okay, I thank you for this. And so as it stands today, you have finally have the 4 receipts for the 4, these that you submitted.
Yes.
And has your challenge been accepted, or have you heard back from the board as to whether or not these challenges have been accepted?
Well, that's a deep, no, it hasn't. So that's a deeper subject matter. Initially, I was told that I had to resubmit everything. And then I said that I would, but I didn't feel that that was necessary. I also have a recording of being told that I needed to resubmit everything. And I was never actually told to just submit the missing pages until right before the actual deadline. And I was also told, well, we need to see that you at least have one of the pages since you say you had the missing pages. So I sent them 1 page. However, the whole conversation between board staff and myself was about what happened with the employee. It wasn't about going through the challenge process, going through the rebuttal of their decision. And I didn't know that the conversation that they were using was for the rebuttal. I was thinking that it was completely something separate. So I have always been told that I get 3 days to go through my whole challenge process. They ended mine right then and there, and they did not allow me to have the other days to go through it. And I have that as a video telephone call as well.
All right, so,
When I asked for a hearing, I was told that I couldn't waste the board's time.
all right. All right, well, we would like to hear more from you as it relates to the process that
Okay.
you encountered.
Mhm.
And of course, we'll have an opportunity to hear from the board a little later. They will talk about the process as they implement it. And so I just want to make it clear that we're trying to find where there are maybe issues or concerns that can be addressed.
Yes,
And so
ma'am.
your testimony is very important to that.
When
I-
you're
Yes.
Yes, ma'am. When you're asking about the process, is there a way that you can inquire with Miss Marissa Corrente? What process did she use to find that the employee, Maisha Thompson, broke protocol? Because Marissa has originally told me that she saw a video and she saw that she broke protocol and she apologized to me. But then at the board's monthly meeting, she did not ever have said that or ever have seen the video. And when I was in the office last week, I have her recorded saying, I reviewed documentation. I'm very interested in knowing what that documentation is because the only thing that could have been reviewed was the actual video. When I wanted to be prepared for this meeting. So when I did a FOIA request, I got a response back saying that they do not have a video.
All right. All right. Well, You have many parts to your concern.
It's a lot.
And
We probably
it
would need to
is-
meet in private
We,
about it.
we probably should.
Yes, ma'am.
I think whenever we talk personnel matters,
Mhm.
it is better done, because it is confidential. And so, but I wanted to understand the process, what you were anticipating, and especially since you have been through the challenge process before. So as it stands today,
Everything always happens in front of you,
oh, okay.
right at the round
All
table,
right.
always. No one is ever supposed to walk off with any of your documents.
So your challenge using the 4 different sets still stand. You did, in fact, you were able to challenge the petitions of this candidate, correct?
No,
You were not.
I turned them in, but with the 24 pages that was missing, they said that it wasn't an effective challenge. And they're saying that I left out the documentation.
Okay.
When
All
I
right,
did not.
but these are the pages that you actually gave them, is what they're.
No, those are the actual petitions of Trayon White's.
Copies of. Let
Copies
the
of the
public know,
petition.
these are copies
Yes.
of the actual petitions. So
Copies of the
those
actual petition.
are the pages that you submitted to the board.
I have them. I will have to, I'm sorry, I didn't bring those with me today. I thought that you guys would probably wanted to just focus on the forgeries. But I do have, if you look in there, may I approach you?
Of course you can. These are your petitions.
Yes,
They're-
ma'am. I just want to show you something very.
All right, is this, that's one.
Yeah.
Do you need,
No. It's, I gave, so these are the.
you take them back to the witness table and then speak from your documents. Think it'd be better.
Show you mine. Submitted 1 to 28 and 1 to 2.
All right.
Just as an example.
All right. There are quite a few pages here.
Be very thorough. Okay, 1 second.
All right.
Let me give you these.
And Ms. Jenkins, thank you for being patient. These petitions, they're always so important, and it's good to see you, of course. Well, Ms. Woodland, what I'm really trying to
Here
just
they are.
to understand is what was submitted to the board, because it's more than 4 groups there.
Yeah.
And, okay, all right, this is what you
This
submitted.
is the sample I was showing you. Yes, but that's what I submitted.
You submitted, this says 1 through 28. That's what this says, okay.
And behind it, it also says 1 through 2. There's a staple page in the very back for the 2 pages.
Oh, yes, I see that, all right.
Yes.
1 through 28 I have, and, well, this is, no, this is really talking, oh, yes, sheet 2 of 2.
Mhm.
So I guess this is 1 and 1 through 2.
Yes.
And the rest is how to validate signatures.
Yeah.
That's what you provided for us. Okay, and so the 1 through 58,
The 1 through 58 and the 1 through 85, I will have to bring them to
you
you.
will bring those, but you
Yes.
actually have those as well.
I do.
All right, thank you. Thank you very, very much for that. And so the next step would be that within 3 days or at the conclusion of the challenge period, you would be notified as to whether or not your challenge was accepted. Am I correct?
Yes.
Did that happen?
I was notified the very next day after submission that my challenge was not sufficient.
So you were notified on May 1?
Yes.
All right. Was that the conclusion of the challenge period?
It was I guess the conclusion for me from what I
I mean, is
understood.
that, well, we publish, Board of Elections publishes a calendar.
Well, that was the very last day for
Okay, so
submission.
May 1 was the last day.
No, the 30th, the
The 30th was the
29th
last
was.
day. Okay.
Yeah.
And customarily, when you challenged before, are you aware of whether or not it takes a day or 2 or a week?
Well, it kind of depends on how many people they had
I
put in
got you.
submissions.
Okay. All
But
right.
I submitted mine on the 29th of April. By the 30th, right after 12 o'clock, I was notified that my challenge was not going to be accepted because it had missing pages.
Okay. It has missing pages, and the missing pages are from the set that is 1 through 58
1 through 58 and also
and the
1
1
through,
through 85.
yes,
All right. And those you have in your possession,
yes,
and you can provide, would you please provide this committee with that information as
Yes, ma'am.
quickly as possible
yes,
so that we can clear this matter up
yes,
best
ma'am.
that we can?
Okay,
All right. Thank
Well,
you.
yes,
Thank you
ma'am.
very much. All right. Ms. Jenkins, thank you very much for your testimony. And I know the 2021 seems a long way back into our history. But I really appreciate hearing how you feel that the board and our government can better assist candidates, particularly for many, this is a new process. And so I appreciate that very, very much. Now, modernizing signature requirements, and you point out how the school system no longer even instructs in cursor how to sign. So now, what should we really do about that in society? Because almost every document that is legal document does require a signature. And it doesn't dictate that it be cursor, it can be X mark, it can be print, but it has to be in the individual's handwriting. So is that your interest, or are you thinking that the old cursor system is what is the issue? Tell us a little more, your opinions on that.
So that is a really unique situation. I think for me, what's top of mind about it is that it just speaks to how archaic the system is in a lot of ways and how it should just be aligned with what's normal now or meet the expectations. So maybe I think one way to kind of speak directly to that is that if we have an X or if we have a signature that can be easily construed. So, for example, you might sign on a flat surface, you might sign when you're getting stopped to, carrying groceries, or it might be inclement weather. And there are lots of things that can compromise your signature or also prevent you from actually penning to paper. And I think that's where the ambiguity comes in and where the petition process can be weaponized. So someone could actually say, hey, that's not a healthy and fit signature. It's not valid. That's not Laniqua Dominique's signature. And then the candidate has the burden of trying to prove and confirm, because the Board of Elections does not provide a rubric on how to do corrective actions, proving that that is a healthy and fit signature. So I think that more so is the emphasis that I was trying to create, that maybe it shouldn't be there, or maybe we could have it electronic where someone could just put an X, but also thinking ahead and saying, how do we limit the weaponization of this process when so many of the validating factors are kind of archaic or out of touch with the curriculum in DC school system?
All right, well, I certainly appreciate that, and you have generated, I think, some food for thought. But the question still remains, how would the board or any other organization certify that the markings on the petition form are in fact the markings of the person at the said address that's also on the form? And why is this process important to the elections process? So you've given us a dilemma. And we'll examine it first with the authorities that are responsible for conducting our board. And then I'm sure we will examine it further at the council. And, you may be onto something. I don't know. But we need a way of identifying the voters. And how do we do that is the question you posed to us. So thank you very, very much. I have no solution, but I definitely will talk with the board about it. And we'll talk with legal counsel about any thoughts they have about this process, because it is in fact a dilemma. And I do agree that we want to be as modern as possible. But at the same time, we want to make sure that we are reaching the people who will have an opinion, and that their opinion is collected in some sort of way or manner so that we are clear as to their choices for candidates on the ballot. But thank you very, very much for that.
Also, another thing I think is like when you mentioned legal counsel, it just made me think about like the technicalities and the legal muscle, like formal muscle that's needed to navigate the process when petitions are challenged, and how in most cases, if you can't afford an attorney, you're provided one. And that's very unique when you go before the Board of Elections, that you don't have legal representation. And for first-time candidates or very new candidates that are unacquainted with this experience, most may not realize until they're in the thick of it, like myself, that the next court after the Board of Elections, and you need an appellate attorney to do an appeal to the petition challenge process if you want to pivot, is the Supreme Court, which is the highest court in the United States. So I think that a lot of thought needs to be given about how to be more equitable, more inclusive, and to make sure that the system is fair and that the expectations are clearly articulated for all candidates.
Thank you very much. On your point of electronic petitioning, we do have that process enforced today, where you can actually sign a petition electronically and submit it electronically. But correct petitioning, I don't know, in real time, we need to really work on that to make it work in our modern society. But thank you for your thoughts on how we might modernize the system. Thank you very much. And thank
Thank
you
you.
to the panel. Thank you very much. And sorry to hold you so long. Our next panel, Robert Brennan, Ward 5 Leaders Council, Public Safety Committee Representative, Dorothy Brazil from DC Watch, Robert King, Ward 5 Leadership Council, and Hazel Thomas, the Ward 5 Leadership Council. Okay. All right, we actually have written testimony from Robert King and Hazel Thomas, but I think we just have their written testimony. All right, I believe Ms. Thomas is on. Thank you all for your patience, and we'll start with you, Mr. Brennan. And you're on.
Greetings and salutations, Madam Chair. I am Robert Benson Branham, Chairman of the Ward 5 Leadership Council Public Safety Committee. And I want to take this opportunity to acknowledge the leadership of the co-conveners, Mr. Robert King and Ms. Hazel Thomas. I have served as president and chairman of several community-based organizations in the District of Columbia. I've also served as an advisory neighborhood commissioner. I welcome this opportunity to comment on the Board of Elections rulemaking regarding Initiative 83. I strongly oppose I-83. I do not feel it was an appropriate measure. The decision by the Board of Elections to allow the measure on the ballot was not proper. Moreover, the fact the Board of Elections proceeded to place this measure on the ballot as a matter was litigated in the courts demonstrated the board's lack of respect for judicial due process, restraint, and clarity. In addition, the board's deference to permit and certify altered initiative petitions represents a high disregard for ballot integrity. The fact the board has subsequently determined there was fraud and reached an agreement with a number of IA3 petitioners, circulators, renders the decision-making process of the board dubious. And let me also say, I understand that one of the persons that the board indicated had access to the determination has denied signing the agreement. So it's questionable whether or not the board is being honest with the public. For the record, I have sent a letter, a personal letter to the DC Attorney General, Brian Schwab, recommending his office investigate those who admitted their wrongdoing. It is clear the board members are advancing their own personal political interests rather than safeguarding District of Columbia voters. Even following a rebuke from the DC Court of Appeals, the Board of Elections continues on the disreputable path of codifying this devilish scheme to fraud the voters of the District of Columbia. What should come out of this hearing roundtable is to remind members of the Board of Elections their sworn obligation is to justice and truth. The purpose of citizen-inspired initiative is to increase citizen participation and to give greater voice to the people. However, it should not be used as a vehicle to game the political legislative agenda to promote ideas. I welcome this committee's oversight and determinative guidance to the Board of Elections to protect the ballot initiative structure inasmuch as the board does not address another concern. I also feel the council should enact legislation to prohibit persons, either through conviction, confession, admission, or agreement, to participate in any manner with any initiative effort for a minimum of 3 or 5 years. I also want to say to several organizations who were supporting Initiative 83, placing words like free and democracy in your organization's name does not shield you from being corrupt, dishonest, and hypocritical. And I'm also disappointed that many of the media, local media, such as the Washington City Paper, the Washington Post, and 51st News, have failed to report the fraud findings of the DC Board of Elections and Ethics and have yet to address that issue for the public's information. I thank you.
Thank you very much, Mr. Brennan. Ms. Brazil?
Good afternoon. My name is Dorothy Brazil, and I would like to make a brief statement and raise certain questions. First and foremost, I'd like to read a letter I sent to you yesterday, Ms. Bonds, and your staff. It reads as follows. In preparing for the May 13th CAL hearing, I need to make some critical decisions regarding the tone and substance of my testimony. After reading the roundtable notice and speaking with concerned DC residents, I have revised my initial impression regarding the true purpose and intent of the hearing. Following certain highly questionable decisions by the DC Board of Elections last year regarding Initiative 83 and the subsequent widespread call by citizens for an investigation of the BOE, I had been led to believe that your hearing today would be the initial first step regarding an investigation. Instead, it's the standard poorly prepared oversight hearing by this committee. In addition, Ms. Bonds and the committee seem to have chosen a disturbing path by giving great deference to the DC Board of Elections by indicating that at the hearing, the board will discuss a number of important issues regarding ballot initiatives, quote, in order to ensure the integrity of the process and provide transparency to the public. It is now clear, Ms. Bonds and your staff, that you need to read and research the highly questionable and illegal actions the Board of Elections took last year in support of Initiative 83, especially the use of whiteout, correcting fluid, and/or tape on the initiative petitions. Bottom line, I'd like to know, Ms. Bonds, whether or not you and your committee intend to ever investigate the Board of Elections with regards to Initiative 83 and a host of other matters. I will quickly go through a number of things that I also want to add for the record. First and foremost, it is clear in the order that the Board of Elections issued last month that they knew in March of 2024, I stress March of 2024, that the Initiative 83 committee was considering the use of whiteout. They were then instructed by the Register of Voters, Marissa Correnti, not to do so. However, between the time of March 20th and the time the petition sheets were handed in, and the Board of Elections issued its decision on August the 2nd, 2024, the Board of Elections did nothing. And instead, at the August meeting, they approved the measure as for placement on the November ballot. The question I have, and indeed that everyone has, what did the Board of Elections know? And when did it know it? There is an email trail between the I-83 committee and the Board of Elections, specifically noting that the committee intended to use whiteout, and the committee was instructed not to do so. We don't know, but we suspect that the Board of Elections did nothing. The second matter I'd like to raise with you is the issue of administrative orders. In my long history of following the Board of Elections and the Office of Campaign Finance, decisions of the agency are memorialized by an administrative order. The Board of Elections, at its August 2nd meeting and subsequently, decided not to issue an administrative order. No explanation was given for its decision to approve Initiative 83, other than they said so. And instead, when asked by the DC Court of Appeals why no administrative order was issued, the Board of Elections invented a new term they'd never used before. They simply said the decision by the Board of Elections was a ministerial act. When asked at the hearing before the Court of Appeals, an attorney in the Office of General Counsel could not define what an administerial act was. The next thing I would like to bring to your attention is the fact that as part of the board's decision, they issued an administrative order, and attached to it was a stipulation. That stipulation details some additional facts about the whiteout issue, but it also indicated that all 4 circulators of Initiative 83 had signed that stipulation. I have with me today a copy of that stipulation. There are no signatures on that stipulation. And indeed, last week, when I asked at the monthly meeting of the Board of Elections, how can you have a stipulation between parties and the Board of Elections, and there are no signatures on the stipulation? The General Counsel for the Board of Elections, Terry Stroud, indicated it was because of PPI. After 3 times, I said, what is PPI? Personally identifiable information. She indicated that no signatures were on it, and indeed, she claimed that the signatures had been whited out. That sounded familiar. I have subsequently asked the Office of Secretary of the Council, since the council website operates with a lot of documents that bear the signature of council members. And I asked them, do you subscribe to PPI? They didn't know what I was talking about. I find it interesting and troubling that the Board of Elections continues to invent new terms, new methods to get around what they're supposed to be doing, namely protecting the rights of DC residents when it comes to elections. The last thing I would like to mention is my concern about a bill you have introduced, Ms. Bonds, called the Petition Administration Clarification Amendment Act of 2025. When I last checked, no hearing has been scheduled on it. But I must ask, after reading the memorandum that accompanied the bill, as well as the bill, I must ask, on the record, who wrote this legislation? For example, it clearly states in the memorandum you signed that nothing in district law addresses the legality of alterations or changes made to information added by a petition signer to the petition form. That is not true. We have long had a practice and reference in the code and in the regulations regarding a petition circulator is not to alter the information that a signer has put on the petition, whether or not it's their signature, whether or not it's their printed name, whether or not it's their address. The only flexibility that there has been is as regards the ward identification and the date. So, Ms. Bonds, since this is, I assume, going to be coming forward soon, I would like to know who wrote this bill for you. And I ask you that you withdraw it and have your staff review it and review it in light of what existing law says, because this is not correct. There are provisions in law and in regulations that say you cannot willy-nilly alter an address, alter a name, alter a signature, alter an affidavit. And if there's any doubt, I'd be happy to sit with your staff and point out the provisions in the law and the regulations. Thank you.
Thank you very much for your testimony. And I believe Hazel Thomas is on. Ms. Thomas, we'll take your testimony now.
Thank you, Councilmember Barnes. I had to unmute. Can you hear me?
Yes, we can.
Okay, thank you. Good afternoon. My name is Hazel Bland Thomas, and I'm co-convener of the Ward 5 Leadership Council, along with Robert Bob King, lovingly referred to as the mayor of Fort Lincoln for life. Bob and I defer to Robert Branham, who is chairman of the Ward 5 Leadership Council's Crime Safety and Judiciary Committee. So my comments are going to be brief. I am also here as a legislative co-chair of the DC Democratic Women's Club. And I am, oh, I forgot to put on my video. Sorry. And I am also a Ward 5 Democratic Committee woman. Let's see, there I am. Come on, what's wrong?
Now we see you, okay?
Now you see me.
Yes,
Okay.
very good. Thank you.
Okay. And I was kind of crowded here on my desk. And I also have fought many battles alongside you, Councilmember Bonds in Ward 5, when we served on the Ward 5 Ward 5 Executive Democrats Executive Committee. So while I know you to be having a balanced perspective, I know your heart is with the people. Our organization, that is the Ward 5 Leadership Council, was founded on February 18th in 2023, and it's comprised of civic leaders, ANC commissioners, community, religious, and business leaders in Ward 5, all of whom are committed to advocating in the council and before the mayor on issues of importance to Ward 5 residents, especially those issues that are pivotal to long-term residents. We're especially committed to working with the 3 council members who live in Ward 5. Councilmember Zachary Parker, your Councilmember Anita Bonds, and Councilmember Kenny McDuffie, who chairs the Economic Development Committee. And we do this to advocate for programs and budget items that benefit Ward 5 as well as the larger community. I would simply like to underscore what Robert Branham has stated and reinforce to the council members and your staffs in this roundtable 3 issues that should be kept in the forefront of your minds. So, number 1, the DC local proponents of Initiative 83 were backstopped by a well-heeled national organization that sought to influence, to direct our local political infrastructure to their benefit. We all know that DC has long been a petri dish for outside influencers to experiment with policy and programs that can be replicated throughout the country. However, with Initiative 83, their intent was to use their $1.5 million of dark money to impose, that is, to impose their will on DC residents through the use of their exorbitant funds to pay the petitioners. Number 2, make all votes count, which is this misleading name of the local organization brought in dozens of people to do petitions from out of town. And these people had little or no regard for our local DC Board of Elections regulations. The national organization that supported them is an experienced, well-oiled machine. The out-of-town petitioners use whiteout to alter the names and also the addresses of numerous signers of the petitions, which is a deliberate affront to the regulations governing DC elections and clearly stated petition guidelines. So the third thing is number 3, the national leadership of the proponents of I-83 were knowledgeable and experienced in running local campaigns to influence local politics to achieve their desired outcome. Sadly, they took advantage of the Board of Elections system that was established for voters and citizens engagement, and they manipulated it to their advantage. They were well aware that we only had 2 of the 3 members of the Board of Elections actively participating and a limited number of staff to review and count the petitions. The limitations of the Board of Elections were also most assuredly counted in their decision to ignore the regulations and send the altered petitions forward. They were counting on the Board of Elections being short-staffed, coupled with their unlimited responsibilities. I have several recommendations, and I'll be brief. Number 1, Ward 5 Leadership Council would like to recommend that the positions of the 3rd Board of Elections members be filled immediately. We cannot afford another maneuver like that of the sophisticated lobbyist affiliated with the Initiative 83 advocates to use their bottomless pit of funds to push their slick advertising and promotional campaigns on DC residents who, to this day, don't know what they voted for in November 24th. I dare say there's some politicians in high position high positions who don't know what they voted for on November 24. Their campaign slogan, quote, make all votes count, close quotes, sounds altruistic, but it's really very misleading. Number two, we strongly support expansion of the DC Board of Elections to 5 members. The 2 current members come from the same census tract, although they're from different wards. As the outside influences become more dogmatic and sophisticated, we need an expanded board whose members have a broad breadth of experience and expertise. Most importantly, we need knowledgeable board members who come from wards 5, 7, or 8 who represent the interests of their communities, so that these predominantly Black wards are not excluded from the survey counts and thereby prohibited from impacting the final outcome. Number three is last. The out-of-town leaders of Initiative 83 are now ready to use their sophisticated marketing campaigns to dictate yet another outcome, and that is the outcome of the RFK Stadium decision. In the same manner that they influenced Initiative 82, which had to do with the tipped employees, and the initiative that decriminalized marijuana in the District of Columbia. They have been empowered to once again use their dark money to overshadow the Board of Elections policies and guidelines. This committee has meaning your committee, Madam Chairperson, this committee has an oversight responsibility to protect the residents of the District of Columbia from election fraud and abuse. Number 4, finally, we recommend stiff penalties for persons and organizations that ignore the guidelines and the DC law in lieu of doing what they choose to do in violation of the laws. When we allow people to ignore the rule of law at any level, nationally, locally, chaos occurs. Furthermore, we don't just need a carrot, we need a stick to require outside influencers to respect our election and petition laws. Person who violate DC election laws should be held accountable, and be prosecuted to the fullest extent for fraud. Madam Chairperson, thank you for this opportunity to speak to you at this roundtable on behalf of the Ward 5 Leadership Council, the DC Democratic Women's Club, and of course, the Ward 5 Democrats. Thank you. Are there any
Thank you.
questions?
Thank you very much for your testimony. Thank you to the entire panel. Yes, Ms. Thomas, I do want to make sure that when you are speaking of the process by which the I-83, I'll say proposal was placed on the ballot, you are indicating to us that this was a national focus. Am I correct?
It is true.
Okay.
It was funded and promoted by a national organization.
All right.
Very well funded.
All right. And so being that we are the nation's capital, we're very familiar with national groups coming and staging their protests or their desires on impacting their desires on DC. And so what are your thoughts about that process as it relates to, are you proposing that there should be a prohibition against outside influence, or give us more, because keeping in mind that this is America, and what does that really mean?
This is America, and this is the nation's capital. And so, no, I'm not suggesting a prohibition. I'm suggesting that we have to, as a jurisdiction, make sure that our guidelines and our rules take that in consideration. As you will, if you will, I mentioned several times that this was a sophisticated group. And they are very sophisticated because they've done this many places throughout the country. They take over, and I mean, I call it the hostile takeover to influence local politics. No, I think that what we have to do is to make sure that we have adequate staff at the Board of Elections who are aware of what is going on, as well as we need to empower local organizations and because I'm a Democrat, but I mean independents as well as Republicans, empower the people so that they know what is occurring. And what happened with Initiative 83 is that so much occurred in the dark, outside the purview and the vision of the regular, ordinary citizens and voters, and they listened to the slick slogans: "Make America, not America, make great, make all votes count, all votes count," and they wanted to do what's right. When you have people of certainly people of African American extraction who have gone through, everything from Jim Crow to Civil Rights era to Jim Crow 2, they're very sensitive to those issues. So we have a responsibility to make sure that people are apprised of what is going on, and that we have not the Board of Elections, which of course has to be very unbiased and very fair, but we have to be sure that our political leaders, our local organizations inform the general population of what is actually occurring, because they will look at the surface, not dig down and see what's behind the surface or under the surface, and they will do what they think is fair to other people because of their experiences and the experiences of their forebearers.
I hear you, Ms. Thomas. I think I'm also hearing that you feel very strongly that matters that are placed on the ballot in the form of an initiative must be clearly explained. And I'm thinking about the ballot form that you and I use whenever there's an election, and there is limited space for a real explanation. I'm just wondering, how do you see, or have you given thought to what are some of the changes, the basic information that should be articulated through the initiative language, like you use as an example in what we voted on, make every vote count. Well, of course, every vote is counted. That is the tradition and that is what happens. But to utilize a theme like that, it is very misleading. It implies that in order for every vote to count, you've got to vote for this document that is hereby placed on the ballot. Is that what you're sharing with us?
That is absolutely, you interpret it quite well. And the thing is, maybe it could be as simple as, rather than having 20 names on a sheet, maybe we need to have 15 and a brief explanation as to what this ballot is for. I mean, that sounds simple, but sometimes the simplest things can be the most effective. We simply do have to find a way to help people to understand. There are some people who follow, not everybody's going to be a Dorothy Brazil and follow politics on a daily basis, 24/7. So they do need to have some explanation as to what is occurring and how they can be, and I use the term manipulated, because that is in fact what happens when you use language that implies that, to not use it would be, you would be hurting other people who need access to the ballot. And it's very important to remember that we do in fact make all votes count, even right up until the day of the primary and the day of the general election. People can change their affiliation and everybody gets to vote. And so to imply otherwise is fraudulent, in my opinion.
All right, I see thank you very much for that. I see Mr. Brennan. He
Thank
wants to
you.
comment. This is his arena. Go right ahead, sir.
Thank you. And I want to follow up with what Hazel has said. Madam Chair, and to the members of the council and those who hear me, we can have all the laws necessary intended to protect the integrity of the ballot and to do what is correct for the people of the District of Columbia. But unless we have gatekeepers at the door acting on behalf of the people, those laws will become meaningless. The Board of Elections over the years has transformed itself from an entity working on behalf of the people. I remember the Board of Elections went on chaired by Robert Martin. That's a long time ago. I did one of my first elections. It counts was with under Bob Martin. So I'm not a novice to this, but I think it's critical that the board's integrity is at issue, which is primarily a lot of what Dorothy had to say, following up on what Hazel has said. The board itself has lost and is losing trust of the people of the District of Columbia and to some extent members of the council. And that needs to be addressed. That needs to be addressed. The board members went against their own registrar's advice and determination, and said that the people were told, do not use whiteout. The board let them do it anyway. The board had the current board makeup has no respect for the integrity of the ballot and the integrity of the people of the District of Columbia. And that needs to be addressed. And the board should not be able to escape. The board has put some barriers between itself, has now put up barriers physically and intellectually against the people of the District of Columbia. And that should not be permitted. And it gives a gateway to people in Congress and a president to come in and treat us the way they do, because we have officials who aren't willing to look them in the eye and tell them no.
Thank you. Thank you very much for your comment, Mr. Brennan. I wanted to move to some of what you indicated in your concern as it related, again, your concern with the initiative process primarily, am I correct?
Yes.
All right. And in that, you are indicating that you've sent a letter to the DC Attorney General to take a close look at the board's proceedings. Am I correct?
Specifically, the letter was asking the DC Attorney General to investigate the persons cited by the DC Board of Elections as having committed frauds in a statement that the board said they had consented to have done. So, and the statute says that those who committed fraud, petition fraud, that the DC Attorney General shall investigate and determine whether or not formal proceedings should be undertaken. So that my request was for the DC Attorney General to follow that statute and actually investigate what the work of the DC Board of Elections and its findings that fraud was committed by a specific number of people.
All right. And we'll follow up with the board as to where they are with cooperating with the Attorney General in the event the Attorney General has actually reached out to them.
I also sent it to the Board of Elections also.
Okay, excellent. Thank you. And Ms. Brazil she's no longer here with us, but she has made a few points that she wants follow up on. And so we will follow up with the board on those. Okay. And I will go on record indicating that the language in the legislation that we have proposed about the petitions is accurate. We too go through a review process with the general counsel, and our general counsel has indicated that we are accurate. So we're going to stand by that. And that's for Ms. Brazil's understanding. In the event she will play a recording or is able to, recording of today's hearing, or is actually listening now. So thank you. Thank you very much for your testimony.
Thank you.
And thank you to our witnesses. We will now move to our next panel. Ms. Attorney Deidre Brown with vote no on Initiative 83. Werner Claiborne, the Ward 5 Economic Development Group, and Sandra Seegers, the First Friday Group and Concerned Residents Against Violence. I see Ms. Brown. Ms. Brown, we can start with your testimony when you're ready.
Great. Good afternoon. My name is Deirdre Brown. I'm testifying today in my capacity as chair of Vote No on Initiative 83. Thank you for the opportunity to speak on the operations of the DC Board of Elections. My testimony builds on statements I previously submitted to this council on January 11th and February 19th of this year. What's new is the board's own April 9th, 2025 Memorandum of Opinion and Order, which confirms the fraudulent use of whiteout on Initiative 83 petition pages. This new evidence underscores the urgent need for reform. First, the Board of Elections was aware that circulators were using whiteout during the petition circulation period. The April 9th order makes clear that staff received emails raising this exact issue as early as March 2024. Yet no guidance was issued, no warning was given. Instead, the board allowed thousands of altered petition pages to proceed through the verification process without explanation. That inaction enabled Initiative 83 to qualify for the ballot despite widespread misconduct. This silence, despite clear knowledge, seriously undermines public trust in the process. Second, the board's certification process was arbitrary and capricious. The board rejected 4,802 signature lines due to altered addresses, but accepted thousands more that were also whited out, based solely on the subjective method of holding pages to the light. This kind of guesswork is no substitute for legal clarity. The board claimed it was interpreting voter intent, but voter intent is what the voter wrote, not what a circulator changed after the fact. It is, in its own words, the board called whiteout a material alteration. If that's true, then applying that rule inconsistently is indefensible. This selective enforcement damages the integrity of the initiative process and opens the door to accusations of political bias. Third, it was a grave error to allow Initiative 83 to appear on the November 2025 ballot despite 2 pending legal challenges. The board knew of credible allegations of petition tampering, allegations that later confirmed, but advanced the initiative anyway. That decision has caused public confusion, wasted resources, and weakened the legitimacy of our ballot process. Fourth, I want to acknowledge and commend the introduction of Bill 26233. This bill wisely prohibits alterations of signer-provided information after a signature is affixed, unless the signer requests help. It's a strong step in the right direction, but it must be paired with clear enforcement, and we must ensure it's not applied inconsistently as we saw with Initiative 83. In closing, I urge the council to formally investigate the board's handling of Initiative 83. No administrative order was issued at the time of certification explaining the legal rationale for the board's decisions. The board knew about the misconduct months before petitions were submitted and chose to do nothing. That in itself demands scrutiny. A council-led inquiry should determine why was no administrative order issued to explain the legal fact and findings to support the inclusion of whiteout signatures in the petition certification process, how many whiteout signatures were allowed to be included in the verification process, and whether the board's failure to act violated principles of due process, including refusing to hold a hearing to address specifics of the whiteout usage that I requested. This appears to be their pattern, as Commissioner Robbie Woodland testified earlier this afternoon to a similar experience. I do not understand why, when members of the public request a hearing on a matter as serious as petition fraud or employee misconduct, the Board of Elections responds by calling it a waste of the board's time. Let's be clear, the board is accountable to voters, not just to its internal schedule, and dismissing public concerns in this way undermines transparency, trust, and the democratic process itself. In addition, the council in its oversight capacity should order that the board adopt 3 key reforms. 1, establish clear written policies or petition alterations. 2, implement uniform evidence-based standards for verifying signatures. And 3, pause ballot certification when legal challenges are pending. This is not just about Initiative 83. Initiative 83 is just what brought these issues to our attention. The flaws in the Initiative 83 process must be corrected, not repeated. The public deserves nothing less than a fair, transparent, and trustworthy election system. Thank you for your time and consideration.
Thank you very much for your testimony. Do we have your written testimony, Attorney Brown?
I'll upload it right. Yeah, I'll upload
Okay.
it. Okay, thank you.
Otherwise, I'm going to have to ask you for the 3 points that you were making.
No
Okay.
problem. I will upload
Okay.
it. No worries.
All right. Thank you very much.
Thank you.
And now we'll move to, I believe it's, all right, Ms. Claiborne, you're next. Come right on.
Can you hear me?
We see you, but now we hear you. Okay. And we've lost the picture.
Okay, can you see the video as well?
We do not see a video. We see you now.
Okay.
And we still hear you. Okay.
Good afternoon, Councilwoman Bond, and thank you for convening this roundtable hearing and your many years of service to the citizens of the District of Columbia. My name is Verna Claiborne. I am a 55-year Ward 5 community member and current activist. I am also a member of numerous Ward 5 groups and coalitions. I am the co-author of the position resolution written after 8 months of research and advanced by the DC Women in Politics group. This document and our organization were the first ones in DC over 2 years ago to raise the alarm about the dangers of ranked choice voting to the Black, brown, senior, and already disenfranchised citizens of the District of Columbia. For today's hearing, I am speaking as a member of the Vote No Initiative 83 coalition. In that regard, I not only support any legislation being considered that will put up more stringent guardrails against big money interests from outside of DC who use untoward tactics, including misinformation, misrepresentation, half-truths, and outright falsehoods to corrupt our electoral system. Their use of these tactics that also include carrots of money to the unsuspecting have the purpose of exercising undue influence on who will be our elected leaders in the city and what legislation that benefits special interest groups will be put on the ballots and then advanced to DC voters. Their use of puppeteers from our own communities to act as the face of and push these efforts is not a tactic new to us, but one that has been successfully used for generations to sway those who don't see behind the curtain and who trust them. I realize the Board of Elections does not hold sway over outside groups with deep pockets coming into our city and going into our communities, particularly underserved ones, and using nefarious means to get people to sign petitions, furthering their attempts to influence and dictate who our elected leaders will be, and thus what laws will determine what laws will be enacted that will determine their lives and how their lives will be impacted. The board, however, can and should invalidate any effort by these groups where demonstrable proof exists that they will, in violation of the law, alter in any form, whether by whiteouts or write-overs or other means, any petitions that they turn in. Not only is this a reflection of desperation on the part of those behind these tactics, it reflects the current acceptable low in today's politics and laws to win by any means, fair or unfair, legal or illegal. We are watching in real time the crumbling and demise of long-standing and well-respected institutions all over the country. The Board of Elections should and must stand firm against these influencers and do the job that every DC citizen has the right to expect from them. Rule against those who try to use trickery and backdoor means to get their way, whether for profit, power, or position. Thank you for the opportunity to be heard today. I'm available to answer any questions.
Thank you very much, Ms. Claiborne, for your testimony. Ms. Seegers?
Yes, hi, how are
All
you?
right, we're ready for you. Thank you.
Okay, it's good seeing you again.
You too.
Thank you. Greetings to all. I am Sandra S.S. Seegers, a Ward 8 resident. The sore loser law, which restricts a losing candidate on the primary election ballot from having their name appear on the general election ballot. Some form of the sore loser law should apply to the expelled elected officials. They should not be allowed to run in the special election that immediately follows the expulsion. Section 1-1001.8, J2, nominations under this subsection for candidates for election and general election to any office referred to in paragraph 1 of this subsection shall be of no force and effect with respect to any person whose name has appeared on the ballot of the primary election for that office held within 8 months before the date of such general election. The Board of Election the Board of Election allows too much cheating. They need to see that forgers are prosecuted. When the Board of Election is so lenient on cheaters, it causes us to have poor representation in the elected officials, the council, the mayor, and the commissions. I request that every candidate who filed forged or fraudulent signatures in the special election be prosecuted. The Board of Election needs to do better because every misstep that the Board of Election does causes a misstep in the election, which means they are performing like the Electoral College by silencing the voters. And that's my statement. Thank you.
Ms. Seegers, we missed a little of your testimony. Could you start with the code section 1-1000.08 of your written testimony and put
Okay.
it on the record, please? Now that you're back with us, okay.
Okay, I didn't know. Okay, that section, nominations under this subsection for candidates for election in a general election to any office referred to in paragraph 1 of this subsection shall be of no force and effect with respect to any person whose name has appeared on the ballot of a primary election for that office held within 8 months before the date of such general election. The Board of Election allows too much cheating. They need to see that forgers are prosecuted. When the Board of Election is so lenient on cheaters, it causes us to have poor representation in the elected officials, the council, the mayor, and the commissions. I request that every candidate who filed forged or fraudulent signatures in the special election be prosecuted. The Board of Election needs to do better because every misstep that the Board of Election does causes a misstep in the election, which means they are performing like the Electoral College by silencing the voters. Was I heard?
Yes, you were, and thank you very, very much for that. We
Okay, you're
appreciate
welcome.
that. Thank you. Let's see. And I think that's it, isn't it? All right, that's the third panel. And so we'll start with you, Ms. Seegers, very quickly, if that can be. You say this is a concerning part of your statement, that the board allows too much cheating. What does that mean? I mean, explain to me, how does the board allow cheating?
Okay, one, the whiteout on Initiative 83.
All right, okay.
Two, letting forgers get away with it without prosecuting. So that's cheating to me.
All right, I got you. I just thought it might be something else that you were bringing up.
Oh,
I didn't
no,
know. Okay,
the
thank
same
you.
stuff we heard.
All right, okay, we're all on the same page. Thank you so very much.
You're welcome.
And I take it that you are definitely against the use of whiteouts on the petition form.
Yes, I see cross out, but not by the circulator, by the actual signer.
Okay, so you're okay with crossouts
If it's done by
a
the signer, yes, but not whiteout at all. No.
All
Never.
right. All right. All right, thank you very much. Ms. Claiborne, thank you very much for your perspective. Let me ask you, what is your thought on whiteouts on petition forms, or any markings on petition forms that are not in the designated categories for signature, address, and date? What's your thought?
I would say that those persons who are solicited to go out and collect petitions, they need to be trained on what they need to say to anyone they are stopping and asking to sign petitions. And that once those individuals sign those petitions, that if in fact there is some error that the collectors or those who are reviewing them before they turn them in determine, they should not be able to alter the petition in any way. And if in fact they alter those petitions by whiteouts, by scratch outs, by any other means, then that entire sheet should be invalidated. In the same way that if with this legislation that was passed, the ranked choice voting, there are multiple ways that people who did not understand what they were voting for, that Initiative 83, which is a backdoor of ranked choice voting, they did not understand that there are multiple ways that their ballots will be discounted because of mistakes that they make. Like if they vote for two candidates and vote both of them number one, their ballot is going to be discounted. So in the same way, no petition should be able to be altered in any form and submitted to the Board of Elections and approved.
All right, so you've spoken of the signing or the processing by which a issue, an initiative, or an individual gets on the ballot, and that's through the signing of the petition. But you also spoke of the other situation. You were articulating your concern about when a item is on the ballot and the item speaks to, for instance, ranked choice voting, the fact that individuals may vote for a issue, but they may not know exactly how it would become applicable. Am I correct? Is that what I heard?
That is absolutely correct. As I indicated in my testimony, I, along with another member of the DC Women in Politics, spent 8 months looking at issues with respect to ranked choice voting around the country. And there are any number of what I would consider tactics that were used by those promoting ranked choice voting. First of all, know that Initiative 83 was a backdoor to an attempt several years ago to put ranked choice voting on the ballot, but it never got out of committee with the council. So they came back with this, fooling people, telling folk, and we know for a fact that this happened because I went over into several communities, Ward 5, Ward 7, Ward 8, telling people that their votes did not count. That was absolutely not true. If they choose not to be a member of a party and vote in that primary, then they could not vote in the primary. But to mislead people and an absolute falsehood tell people that their votes didn't count, that is not true. Anybody who votes in the general election, if they are eligible to vote, their vote counts. In addition to that, what they did not tell people as they promoted this notion of Initiative 83, everybody gets to vote, they did not tell people how many ways their ballots could be discounted. That's number one. Number two, the other thing that is really interesting is that they push this notion that this Initiative 83 and the ranked choice voting will get you the person elected who gets 50% of the vote plus one. That mathematically is just, it doesn't even exist. It's stupid. That cannot happen. If you have 5 candidates on a ballot, as an example, and people come out and they rank 5 candidates, eventually what's going to happen before you get a winner, 4 of those candidates get eliminated as a result of rounds. If one candidate initially does not get 50% of the vote plus one, as you eliminate those other 4 candidates and you end up with the last person standing, as what happened in Louisiana and several other jurisdictions, you may end up with the candidate that nobody wants. But more importantly, there's no mathematical way that candidate that ends up standing when the dust settles gets 50% of the vote plus one. They cannot mathematically get 50% of the people who voted plus one. So there were a lot of misconceptions, misrepresentations, half-truths, and just outright falsehoods. And so I think that I don't know if this is really the responsibility of the Board of Elections, but there need to be some guardrails that will protect the citizens from folk who come in from outside of DC, who have big money, from using nefarious means and untruths and misrepresentations and getting people to vote for initiatives or get initiatives put on the ballot. And as well, I'm not sure if it's illegal for you to pay people to sign petitions, but it seems to me that is that is also a practice that I think needs to be investigated and looked into.
Ms. Clyburn, are you telling us that you have some indications that individuals were paid to sign a petition form?
I am absolutely telling you that. Yes.
I see. All right. Well, I thank you very much for your testimony. And Ms. Attorney Brown, is that something that you run across as well in talking to the public about the initiative process?
Yes, we heard reports that people were being paid to not only circulate the petitions, but also to sign the petitions. They were also putting a bounty out if certain organizations were able to get their constituents to sign, that organization would get large payments. So there was a lot of money flowing. Yes.
I see. Thank you very much for that. All of these are situations that we're trying to figure out how might we modify the situations enough so that we provide genuine protection for the residents of the District of Columbia. So any of these thoughts that you have are very important, not only where you're saying or sharing with us what the findings may be or what the anecdotal information that's been supplied to you, but also if you have thoughts about how we can better this whole process. The initiative is very dear to the District of Columbia. It is a way for the public to get a burning concern on the ballot, but it ought to be one that is fair and somewhat impartial to those who have the opportunity to sign on to it. And it should be with accuracy as to the description and we can't question the motivation, but we certainly can question the description so that people know what in other words, we know what we're buying, so to speak, when we say, yes, I want to affix my signature there. And then once the signature is on this form, along with the address and the date, we want to make sure that it's respected and it's not altered because maybe I put the address of where I once lived, or I said, oh, maybe I better put the address of when I first signed up to vote and get it wrong. So this is a big concern of mine. Ms. Seegers, I'm stopping. I want to hear what you have to say about that.
Okay, could you tell me if an election you won by 36% of the votes?
Did I?
Yes.
I think it was, when I run, it's two people that are elected. You get to vote for two.
Okay, well, your good friend here in Ward 8, whose name started with P, I won't say the full name.
Yeah.
The reason they were involved in this I-83 is because they said, no way should you have won with 36% of the votes.
I don't know. I believe it was, I don't know exactly. I think it was a little more than that. But the fact is that I won, and the next highest balloting in that position was no vote. And the other person who was elected, other candidate that was elected, won with, I think it was 19 or 20%. In other words, I and the other candidate, one of the other candidates, were elected. The no vote came in second to me. I got more than the no vote. Okay.
Yeah.
Yeah.
And I think you should have won. If you had gotten 1% of a vote more than the next person, you're the winner.
Oh, yes.
That's how I see it. It just stay that way.
Exactly. No, I've been successful to be usually the top vote getter in my category. And I'm thankful to all of the voters who help in that regard.
You're welcome.
Thank you. Thank you. But today, this is, we want the purpose of today's hearing is really to take a look at what we've been doing, the practice, what the regulations say, the interpretation of the law that has been applied apparently in many situations, and see where do we go from here? How do we improve our system of integrity? Because that's what's very important. I think Robert Brennan brought that home, and the testimonies that you're providing us with today are very important. It leads us to that direction. And things have changed over time, as we well know. I was here when we said yes to the ANC process, and we were very excited about it. And now it's become the thing to be a commissioner. Back in the early days, you'd almost have to beg a neighbor to be a commissioner, as you well know, Sandra. And so now we've got competitors. In my single member district, I had competitors. In fact, one of the candidates not only was running and had a flyer, which most of the candidates for ANC use, but had posters and posters on sticks, and they were in yards, and it was like a whole new day. And this was for a single member district contest. When I was the commissioner, I was happy to have my little flyer and get that out and knock on doors and talk to people. And I'm sure Mr. Hinchman remembers some of that back in the day, but times have changed. And we are very much aware that we are the marketplace for anything new. And to say to the nation, I went to DC and I promoted this and I got it done. No one in Washington State or Louisiana asked you about how did you get it done? Oh, you got it done in the nation's capital. So it's really a big deal. And that's why for us, this is so important that we protect the integrity of the process in the district and the integrity of our residents. So I appreciate hearing from you all today. And we will see where we go from here. I think we have we have one more panel, and then we will hear from our government witnesses. And yes, I'm taking a little time because I want whatever your thoughts to be recorded and a part of the record. This is that important to the residents of the district. So thank you again. And I see Ms. Vega. Okay, and do we have Donnie Russell from the University of the District of Columbia?
Hello. I'm sorry.
Okay, I think we cleared up our technical difficulty. Ms. Russell, we see you. Can you hear me? All right. You have to unmute yourself. There you go.
Yes.
Okay, we'll take your testimony and then we'll go back and see if we can get Ms. Berger from the Public Library. You are representing the University of the District of Columbia. Please go right ahead. Thank you.
Okay, great. Thank you. Yes, I represent the University of the District of Columbia for the Office of Student Outreach and Leadership Development in the Division of Student Success, mostly Student Affairs. So the relationship between DC BOE and UDC has proven to be reciprocally beneficial for both government agencies. This partnership enriches the experiential learning for many of the UDC students and alumni. University of DC works to expand internships, research, and professional development opportunities for our students, in addition to expanding partnerships with the other local education and government entities. The programs implemented that I will talk about were targeted engagement initiatives for alumni, policymakers, local communities, and government agencies. The most notable being National Voter Registration Day, which is a nonpartisan civic holiday celebrating our democracy. Celebrated every September, National Voter Registration Day involves volunteers and organizations from all over the country and DC hitting the streets in a single day to create broad awareness of voter registration opportunities. The DC BOE staff, also known DC Board of Elections, staff coordinates with the University of the District of Columbia Andrew Goodman Foundation Ambassador, other organizations on campus like SGA, D9, in a minimum of 4 initiatives per year. Voter registration information is provided by the DC Board of Elections, including hard voter registration applications that can be mailed directly back to the Board of Elections free of charge. UDC also participates in the Adopt a Vote Center initiative offered by DC BOE Voter Education and Outreach Division. The Adopt a Vote Center program, which provides an opportunity for community organizations and agencies in DC to serve their community and encourages civic engagement. The program aims to create partnerships with various organizations and assist the board in staffing vote centers with civic-minded individuals who work well together. Once participating in the organization must provide 7 to 10 people to staff a designated vote center on primary and general election day. The election workers are paid a stipend and trained by DC BOE. Before election day, each member is required to attend a 4-hour in-person class to learn roles, responsibilities, skills, procedures for the election. This training is mandatory for all election workers before each election. This program in particular is very popular among all UDC students, residents, non-residents, international students, regardless of age. It is a great opportunity for all who engage to get a hands-on experience and understanding of the U.S. electoral process. Our students take pride in the fact that their institution plays a part in the electoral process, not only with our students participating as election workers, but also the fact that the Van Ness campus and most recently, up until this past year, Lamont Riggs campus both acted as a voting center and a super voting center. So not only do students get a chance to participate, but they also get to participate directly in the community in which they live and affect. UDC has worked with DC BOE to host voting centers for many voting cycles. This also is reciprocal as DC BOE conducts election worker recruitment events prior to each election. So not only do our students get paid to learn, but the voting center also encourages the surrounding community to visit and explore campus. This provides a great opportunity for DC BOE to keep a continuous pool of qualified persons to hire for the election cycles. The major initiatives above are in addition to general attendance at university events such as the Back to School Barbecue and Spring Fling. Strategic events are scheduled such as visiting the UDC Congress Heights campus prior to the 2025 Ward 8 special election. Strategic events ensure goals are met with the intended target audience. Overall, the interagency MOU partnership has proven beneficial and successful over the years. Concluding.
All right, thank you very much for your testimony. And now we will attempt to get Ms. Dinah Vega from DC Public Library on. Can you hear
Yes,
us?
I
Okay,
can hear
great,
you. Yes.
excellent.
Okay. Good afternoon, Madam Chairwoman and members of the Committee on Executive Administration and Labor. My name is Diana Vega, and I am the Civic Engagement Coordinator for DC Public Library. I began in this role in April 2019 after the DC Council designated DCPL as a voter registration agency. Since then, in my role as Civic Engagement Coordinator, DCPL has fostered a partnership with DC Board of Elections, DC BOE, Outreach Department to be a constant presence at DCPL branches in both election and non-election years. Over the past 6 years, DC BOE has utilized DCPL spaces to provide accurate information about federal and local elections, recruit election workers, and register residents to vote, with DC BOE placing an emphasis on serving wards 7 and 8. In addition to being present at branches, DCBOE outreach staff has also provided informational flyers in both English and Spanish and other election-related materials like voter guides and door knockers to DCPL branches to be distributed, or door hangers, sorry, to be distributed to our patrons. In non-election years, DCBOE staff have provided National Voter Registration Day voter registration drives at various branches to maintain civic engagement and excitement among residents. Here are additional highlights of the DCBOE and DCPL partnership over the past 6 years. In 2020, during the COVID pandemic, while DCPL locations were closed to the public, we partnered with DCBOE Outreach Department to provide Twitter chats where DCBOE representative answered residents' elections questions. DCBOE staff also provided a virtual presentation that was broadcast on DCPL's Facebook and YouTube pages in advance of the 2020 election. In 2022, in celebration of National Voter Registration Day, DCBOE provided go-go voter registration drives at Martin Luther King Jr. Memorial Library and Anacostia Neighborhood Library to register people to vote, provide information about the upcoming mayoral election, and distribute swag and promotional materials. In election years 22 and 24, DCBOE outreach staff have provided presentations about the upcoming elections to DCPL staff who are completing the Civic Engagement SMART goal so they could be informed and serve as a resource to residents during the election season. In 2023, DCBOE held National Voter Registration Day drives at Capitol View, Parklands Turner, and Benning neighborhood libraries. In 2024, in preparation for the federal and local election, DCBOE held voter registration drives at 7 neighborhood branches: Bellevue, Capitol View, Francis Gregory, Lamont Riggs, Petworth, Southwest, and Woodridge. Currently, in preparation for the Ward 8 special election to occur on July 15, 2025, DCBOE outreach staff have tabled at the following locations: Anacostia, Bellevue, Benning, Capitol View, Deanwood, Francis Gregory, Rosedale, and Parklands Turner, and have provided election information to over 80 residents about the upcoming election. Thank you.
All right, well, thank you very much for your testimony as well. And I think we also have Charles Wilson.
Hey, good afternoon, Councilmember Bonds.
All
Charles
right,
Wilson.
glad
If it's
to have
okay,
you on.
yes, if it's okay, I'll leave my camera off. I had to
All right, that's
leave,
fine.
the office to pick up the kid. Good day, Councilmember Bonds. Thank you for convening today's important hearing on the oversight of the DC Board of Elections, the DC ballot initiative process, and specifically Initiative 83. As someone who was involved from the outset in opposing the recent initiative, I have deep concerns about how this process unfolded. First, I was troubled by the initial advisory opinion issued by the Office of Attorney General. Rather than providing legal analysis grounded in case law, the opinion appeared to be based on subjective interpretation and policy preference. The role of the OAG, as I understand it, is to advise the Board of Elections, not the petitioners. Yet in this instance, the opinion seemed to assist the petitioners by suggesting the addition of the subject to appropriations clause in order to bypass legal obstacles. This, in my view, exceeded the appropriate scope of the OAG's role. Their duty is to uphold the law, not to help actors circumvent it. Second, concerns deepened during the initial Board of Elections hearing, where public testimony was heard. It became apparent through side conversations, body language, and interactions that discussions had occurred in advance between the board and the petitioner's attorney. The chair of the board appeared to have already formed his opinion prior to the hearing. I was particularly disheartened when he interrupted my testimony, something he did not do to others. Additionally, in that hearing, he noted that there was an obstacle, legal obstacle, because the Supreme Court had previously ruled on one aspect of what the petitioners were trying to put forth. Third, I'm alarmed by the board's handling of procedural fairness, particularly in its approach to complaints. The board attempted multiple times to dismiss our complaint, delaying the ability of the courts to fully evaluate whether this initiative meets the legal requirements for ballot inclusion. Rather than trying to impede complaints, the board should allow the judiciary to make determinations on such matters. Their actions not only undermine transparency, but also created unnecessary delays in the legal process. The Board of Elections should never advance a ballot initiative for placement until all legal challenges are resolved in the courts. Finally, the broader ballot initiative process in the district is fundamentally flawed. The lack of clear standards from the Board of Elections and the influx of unregulated out-of-state money influencing DC policies is deeply problematic. I urge the Council to develop and pass a fair ballot initiative framework that includes transparency requirements, clear standards for legal review, and measures to protect the integrity of DC self-governance. Thank you for your attention.
Thank you very much, Mr. Wilson, and Ms. Russell and Ms. Vega for your testimony. Mr. Wilson, I'll just ask you clearly, your first concern was, I was trying to record it, but it came through a little, can you repeat that, please, so I record correctly?
Sure. I was troubled by the initial advisory opinion issued by the Office of the Attorney General. Rather than providing a legal analysis grounded in case law, the opinion appeared to be based on subjective interpretation and policy preference. The role of the OAG, as I understand it, is to advise the Board of Elections, not the petitioners. Yet in this instance, the opinion seemed to assist the petitioners by suggesting the addition of the subject to appropriations clause in order to bypass legal obstacles. This, in my view, exceeded the appropriate scope of the OAG's role. Their duty is to uphold the law, not help actors circumvent it.
Thank you. Thank you very much for helping us to understand that. And clearly, the board is effective in garnering the public's support in the administering of the elections, and I applaud Public Library and the university for all of what you have done as a partner with the board. Excuse me. And many thanks from all of us here at the council and the general public. And don't stop, keep going. We need your assistance 100%. I do have a question about the process that you're engaged in. When you say you help recruit individuals that will assist, and I'm assuming, as you have articulated, that there's no one who wants to say no to you, in other words, that you find that they're willing hands. Do you find in your recruitment, if you are familiar with those that are recruited, that it is a younger group or a long-standing younger group, meaning new to the District of Columbia, much more so than, let's say, a group of individuals who primarily are aware of district rules, regulations, laws, provisions that have, let's say, been active in the district for, let's say, more than 10 years? What are your findings?
Well, the first thing I would say is the level of being knowledgeable about the process of the Washington, D.C. process specifically definitely has no like bearing with its age or how long they've been in DC or not been in DC. There are many people who've been here a long time who don't know much about the process, only because maybe they never had anybody introduce it to them on a basic level so they can learn in increments. I will say that University District of Columbia is a non-traditional university. So a lot of our students, which I would have to start collecting data to find out specific percentages. But because our student base is so vast with between being international, metro residency, and vast in age, vast in knowledge background, and spanning from workforce development to the law school, which all students who are enrolled are invited to these events and recruitment events with DC Board of Elections and in conjunction with the Office of Outreach and Leadership Development. So there is no, I would say, from my basic qualitative knowledge, that there is one group that it is more popular with, or one group that tends to sign up more. Because all students from all over the place who come to UDC are interested, one, because it's a paid position for part-time work, but also it allows a lot of students who would not necessarily get the opportunity to participate in the electoral system in Washington, D.C., just that, the opportunity to participate in the electoral system in the nation's capital. And so that goes for international students, that goes from students from every state around the country. So I think the interest is just that. It is just interest in being a participant in the nation's capital's parliamentary and, civic engagement process.
All right, I appreciate that. How about Ms. Verga, the individuals that you're able to recruit? Would you say that they tend to be longstanding library visitors, or are they just those that see a sign in the libraries and say, okay, I want to do that?
Oh, I'm not sure of the demographics because the DCBOE staff is actually tabling and responsible for that part of it. We just provide the space.
I see. Thank you. Thank you. I'm
Mhm.
just curious about how we're getting these individuals to say yes, that they will help. Because there are responsibilities, and there's the training, and in DC you find almost at every poll there are individuals who say, oh no, they gave me my ballot wrong, or they gave me a different color. You know how we are. We're just people, and sometimes we do take issue when we can just settle it very easily. So I was just curious and wanted
Okay, I would
your
like to
feedback.
add to that, just so you know, that because we're a university, we do tend to reach, of course, the younger group of students because we're engaging with campus organizations. So we're engaging with Black Greek life organizations or Greek letter organizations, USGA, GSGA. We have an Andrew Goodman Foundation chapter on our campus, which focuses on nonpartisan civic engagement. So even though we don't have those numbers, we are actively, every time we have engagement events, always touching or front facing with that group of youth.
All right.
That in there.
I appreciate that. Thank you very much. And Mr. Wilson, I think that your young people in your life, your family are too young to volunteer, but what do you have to say about volunteering for the board? Do you know neighbors that have participated in that process?
Yeah, I do have neighbors, many of them seniors, who actually look forward to election season where they can volunteer. And they do it in various capacities. So I think that's something that should continue.
All right, thank you very much. Let me just make sure. All right, thank you. Mr. Wilson, I do want to ask you, have you taken a position as it relates to whiteouts on the petition form? I did ask a few other of our witnesses.
Yeah, personally, I am in alignment with um, the folks who testified earlier that whiteout on petition forms and then the information being altered is not acceptable.
Okay. Thank you very much. And thank you all so much for your testimony, and I won't hold you any longer. And thanks for being patient with us. We'll now move to our government witnesses, and we will start with the Office of Advisory Neighborhood Commissions, and I will swear the team in. Okay. Let me just. All right. And I want to thank the government witnesses from both the Board of Elections and the Office of Advisory Neighborhood Commissions for appearing today to answer our questions, to contribute to the dialogue we've been having. And I'll swear you in at this time. If you raise your right hand, do you swear and affirm that your testimony and any statements that you make before us today to be truthful and complete? Thank you very much. And Mr. Walsh, you may begin when you're ready.
Thank you, Councilmember Bonds. So good afternoon to you and the members of the Executive Committee on Executive Administration and Labor. As I have been introduced, I am Kent Bass, the Executive Director of the Office of Advisory Neighborhood Commissions, and it is my pleasure to be here today. My participation today will be limited to issues that impact advisory neighborhood commissions. In particular, the increasing difficulty related to special elections to fill vacant ANC seats, as well as how vacancies are certified. In each of these areas, the Board of Elections is both empowered and responsible to perform as the primary authority. Unfortunately, through successive amendments to the ANC law that have increasingly burdened both ANCs and the OANC with more responsibilities and involvement in the vacancy filling process, the board has taken a hands-off approach that is wholly unhelpful, burdensome, and contrary to good governance. While the ONC's duty to assist ANCs with these elections may have been logical when that language was added to the ANC law, since that time, the district has implemented same-day registration, vote by mail, and early voting. Not to mention, all of these things increase voter participation in our local elections, and that's actually a great thing. Yet none of these options is afforded to registered voters who wish to participate in ANC special elections. It is also disheartening that the OANC staff who have been conducting these elections have encountered registered voters who are unable to participate because the change of address information that they sent to the board months earlier is not included on the voter list that the board provides to the OANC prior to those special elections. It is also burdensome that the council amended the ANC law to require special elections to be for a period of no less than 4 hours. It is burdensome for the ANCs as they no longer are able to conduct these elections during the evening meetings and now must schedule a special meeting on a Saturday, Sunday, or holiday, putting elections in conflict with religious observations. Equally troubling, it has been the board's refusal to conduct an investigation or declare a vacancy without an ANC first scheduling a special meeting and voting to request the board's action. This is particularly problematic when you consider that in the last 3 years, 2 commissioners were found guilty of committing a felony while serving as a commissioner, making them no longer eligible to meet the qualifications of service. In these instances, the OANC sent copies of the court records to the board, and the board did nothing. They instead insisted that the ANC schedule a special meeting to request action from the board. The question that must be asked is why? The board was given all the same evidence that the ANCs had. Frankly, this is both insulting and abusive of the commissioners who are unpaid elected officials. They deserve better. Nothing could be clearer than the statutory mandate for the board. DC Official Code Section 1-1001.05A3, which sets out the duties of the Board of Elections, clearly states that the board shall conduct elections. These are elections. The board has been out of compliance with the law for years because they determined that ANC special elections are nothing more than a vacancy filling. This is nonsense. In every measurable regard, filling an ANC vacancy is an election due to the following facts. Only registered voters are permitted to vote. And in order to qualify as a candidate, one must fill out the candidacy paperwork at the Board of Elections, meet the statutory qualifications to be a candidate, circulate a candidate petition and get the required signatures. And once elected, the board must certify the election and the candidate must be sworn in. It is time for the board to once again fulfill their legal mandate and conduct all local elections. Our unpaid elected commissioners and every district voter deserves no less. Thank you for your time, and I'm happy to answer any questions that you may have.
Thank you very much, Mr. Bass, for your testimony. And I guess I think it would be appropriate to just let us hear from the board officers, Board of Elections officers, and then we will come back, and I'm sure they have some answers for you, okay? All right, so thank you. So we will now turn to the Executive Director of the DC Board of Elections, and we will swear you in. Thank you very much, Ms. Evans, and your team for being here again. If you raise your right hand. Thank you very much. Do you swear and affirm that your testimony and any statements that you make before us today to be truthful and complete?
I do.
Okay, thank you. Thank you very much. We hear you, we see you, and thank you very much for your patience. We've taken some time today, but wanted to make sure we had everything that seems to be an area for change available and before you. So we'll take your testimony now.
Thank you. I will provide my testimony and then I would love to address the many characterizations of Mr. Bass, which I do not agree with.
All right, that's fine.
So good afternoon, Chairperson Bonds and members of the Committee on Executive Administration and Labor and Staff. I am Monica Evans, the Executive Director of the DC Board of Elections. With me today is Terry Stroud, the Board's General Counsel, and Marissa Corrente, the Board's Registrar of Voters. As you know, the Board of Elections, or BOE, is a charter independent agency And our mission is to enfranchise eligible residents, conduct elections, and ensure the integrity of the electoral process. Planning for the Ward 8 special election, as you know, is underway. The election will be held on Tuesday, July 15, 2025. We have posted the draft Ward 8 special election calendar on our website, and we will operate 4 early vote centers from Friday, July 11 through Monday, July 14. We will operate a total of 12 vote centers on Election Day. The Voter Education and Outreach Team, or VEOD, administers year-round education, outreach, and engagement activities and programs. To prepare for the Ward 8 special election, VEOD registers voters and engages eligible voters within the ward. Our education and outreach events also provide an opportunity for us to recruit election workers. And through our outreach efforts, we target special populations such as seniors, students, and those with limited English proficiency. Our outreach efforts include voter registration drives, tabling at fairs, and attending community events. All eligible Ward 8 residents in the Department of Corrections will be mailed a ballot for the special election. Registration and outreach efforts in the Federal Bureau of Prisons, or BOP, will occur entirely by mail and email. BOE will mail packets of educational and voter registration materials to each facility for distribution by staff to the impacted residents. We have begun our efforts to notify residents about the upcoming Ward 8 special election. We will begin conducting accessibility surveys of vote centers for the special election in June. As needed, we will partner with DGS to ensure that vote centers are structurally accessible. We'll also ensure that election workers are aware of the Americans with Disabilities Act, or ADA guidelines, and are trained to promptly and effectively address issues as they arise. The recruitment of quality election workers is important, and their presence at vote centers requires attention to detail. Ahead of the special election, our goal is to recruit and train between 175 and 200 election workers. We will deploy approximately 145 election workers to serve at vote centers. Election worker training will begin on Saturday, June 7. We are offering training classes for registration clerks, ballot clerks, voter assistance clerks, and site coordinators. BOE will mail every eligible voter a ballot for the Ward 8 special election. BOE is tentatively scheduled to begin mailing ballots on Monday, June 9. BOE will place 4 mail ballot drop boxes around Ward 8. We plan to open them on Friday, June 13. Boxes will be placed in Anacostia, Bellevue, Navy Yard, and Congress Heights. In addition to planning for the Ward 8 special election, BOE is busy conducting list maintenance, assessing equipment needs for the 2026 election cycle, preparing to implement new legislation, conducting outreach, recruiting election workers, tracking national activity and legislation that affect elections, training voter registration agencies, registering voters, updating voter records, conducting inventory, migrating to a .gov platform, refining our continuity of operations plan, and preparing informational materials. As always, it is the board's goal to provide competent, responsive service to every registered voter in the District of Columbia. We will always review, modify, and adjust our processes and procedures wherever possible so that we improve our operations with each election. I must note, however, it is our responsibility to uphold the laws in the District of Columbia and not to act based on the desires of the public. Thank you, and we are available to answer any questions.
Thank you very much for your testimony. We're missing your testimony, your written testimony.
I will forward written testimony to you. Unfortunately, due to some circumstances, it was just finished today, and so I will forward that to be included in the record.
All right, thank you. Then we don't have to worry about a transcriber trying to get all those
Absolutely.
for the record. Okay, thank you very, very much. I I heard some of it clearly, was able to write it down, and so I appreciate that. So I may have missed some very valuable points that you made. I must say, I want to start with responsibility to uphold the law and not to respond to public demand. Please help me understand what that means.
Absolutely. For instance, we have been recently criticized for not reviewing petition signatures and challenging what individuals deem as fraudulent signatures. That is not our role. I believe the process is very clearly articulated as far as the role of Board of Elections. We are to accept petitions on their face, and it is up to members of the public to provide challenges. That is not our role. I understand where individuals may be frustrated when they say this is clearly a forgery or this is clearly an inappropriate submission. However, that is not part of our charge. And I think you get into trouble when we start overstepping our boundaries and what has been laid out for us, and we take responsibility for things that have not been delegated to us.
Okay, and so I think you're articulating to us that petitions that are submitted to the Board of Elections are examined when they are challenged by the public. Am I correct?
Yes, as you
Okay.
nominating petitions. Yes, there
Okay,
is.
these are nominating petitions.
Correct.
Okay.
Correct.
Okay. And so we've heard a lot today, I have to ask, because we've heard a lot about the initiative process. So is that true for the initiative process as well?
We do have a process where we review signatures for that process, not for the nominating petitions.
Okay, and you look at all of the signatures or a subset of the signatures? Because we're talking, what is it, like 100,000 thereabouts was once, one
not
time
sure.
a claim. That's a lot of signatures, my goodness.
I'm not sure the number. It was a very significant number we got. We're trying to look that up now.
All right. And you have with you Ms. Terry Shroud, who is your general counsel, and someone else?
Yes, Marissa Corrente is our.
Okay, Ms. Corrente, okay.
But we can get the number for you that was submitted for that. I just don't have it right in front of me.
Okay.
What was the question? The number of petition signatures we received Friday. She was talking about the list and going through them. We can get that for you, Council.
All right, okay. I think the most recent information we had about the Initiative 83 was that you found about 126 signatures that you questioned, and you actually find the group that did the process. Am I correct?
So, well, in terms of the number of signatures that were whited out, we looked at the ones that had been circulated by 4 particular circulators who were part of the committee. And those were the individuals whose signatures that were whited out, we find them for. So this was the enforcement portion of that process. And we never said that we weren't going to take action against those circulators, and we did that. And those were the circulators that we issued the fine against, a fine of $300 per signature that had found to be whited out, where that white out was not done to clarify an address, but to alter the address altogether.
All right, and so it was four of the circulators that were fined, correct?
Right. And so about the total number for, I thought that you were asking about the initial count with respect to Initiative 83. And we can talk about the process later. I understand that you wanted to figure out what the process was with respect to how these petitions are processed. But the initial count, based on the information I have, was that there were 35,124 signatures, which was 12,568 signatures over the number required. They had 8,528 pages.
Okay. All right. I was just trying to get to a sense of the number, and I knew that it was clearly a tremendous number of signatures. That's the only point I was trying to make. And so you've indicated that this whiteout situation that you've heard about today from some of the public witnesses was engaged in by and cited 4 of the circulators. Am I correct?
Yes.
All right. Thank you very much. Okay. And so when you talked about, I believe
there were 42,640 petitions. 14,867 were rejected as invalid. That meant that the petition contained 27,773 valid signatures from DC voters, which meant that it contained 5,235 signatures above the number needed citywide, and it met the ward signature requirements in one more ward than the 5 that were required.
Okay, and so the total number of signatures for I-83 that was submitted to the board was 42,610?
40.
640? Okay, and of that, 14,000 were rejected.
14,867. So there were 27,773 valid signatures left. And that meant that they had more than enough to meet the citywide and the 5 ward requirement.
All right, so that is how the measure was placed on the board. It met the, I guess, the regulation requirements, correct?
Well, beyond the regulations, the charter requirements.
The charter, it's the law of the land. Somehow the charter has become the lifeblood of the District of Columbia, I suppose. But the charter it's like a blueprint, and there are laws that the council, whatever the council members are, enact. And those are the laws that we follow, which is our code. Am I correct?
That is correct.
Okay, all right. I just want that real clear to the public, because people get mixed up with the charter says this, the charter says there shall be a mayor and an elected mayor and an elected council, but it doesn't say how we are elected. It just says what the division of labor is. Am I correct?
I don't necessarily think I would.
Okay, all right. Well, I shouldn't try to interpret the District of Columbia, but I'm just trying to make a point that there is a lot of confusion when we say the charter this, the charter that, the law that, the regulations that. And somehow we have to have some understanding of, it's like a baseball game. Who's on first? And who's on third? And who's running in to home plate? And it's very, very confusing. I continue to hear that folk don't know what it is that we have to follow as a government. So, Ms. Strode, what is it that we follow in the Board of Elections as part of our government? What's the bottom line for us?
I mean, we follow the charter, we follow several statutes, including, of course, for us, the Elections Act. are regulations. I mean, federal laws, Help America Vote Act, National Voter Registration Act, the ADA. I mean, it depends on what the context is, but in terms of district law, the charter is the law that you don't want to enact laws that conflict with that, and you want to follow that above other laws. So to the extent that we promulgate regulations, we want them to be consistent with the charter. We want them to be consistent with the election statute. So we follow whatever laws are applicable depending on the context.
All right, okay. All right, so for you, the bottom line is what the charter says. All right, thank you very much for that. And so to that end, when Ms. Evans says that the responsibility of the board is to uphold the law, she really means to uphold the charter? Is that what we're saying?
Whatever laws are applicable.
That's one of them, but not just the charter.
Okay. All right. Thank you very much for that. I was trying to. So when we talk about the Board of Elections readiness for the Ward 8 special election, there have been some discussion about the candidates that we may find on the special election ballot. And to that extent, I wanted to go back to a point that I believe Ms. Seegers made, and that is the Sore Loser Act. Are you familiar with that?
Not completely. I was listening to her point, but I didn't follow the full extent of the point she was making by stating that.
All right. Well, her point was that law stipulates that if you are vying for a position and you misuse the law, I'll read it right here. It says, it restricts a losing candidate on a primary election ballot from having their name appear on a general election ballot in the same election year. And because of that, the sore loser law should apply to expelled elected officials. And she's getting to the circumstances that we find ourselves in with the Ward 8 special election. And she cites, reference to the code, I believe, 1-1000.08J2, nominations under this subsection for candidates for election in a general election to any office referred to in paragraph 1 of this subsection shall be of no force and effect with respect to any person whose name has appeared on the ballot of a primary election for that office held within 8 months before the date of such general election. And so she's really suggesting that we should have that rule applied to a situation when a individual is expelled as an elected official. So that's what I wanted to know, if you were familiar with that language at all.
Well, as you know, I'm familiar generally, but I don't take a position on it. We don't take a position on pending legislation. We provide factual information and information on how it will affect our process. But as far as having an opinion on that, I do not.
Well, I have
Okay.
a legal opinion on that, and that is that it is inapplicable to the candidate that we're talking about being on the special election ballot.
Yes, I know the current law as it is.
On that.
I think she's suggesting that perhaps we need a provision that speaks to an expelled candidate. That was the That is the understanding I have from her presentation earlier today. And
Yes.
I was just wondering if you're familiar with it.
Yeah, and I think the issue is that during a previous board meeting, Ms. Seegers understood this provision to prevent the expelled member from being on the special election ballot. This is not the first time that she's raised this provision. And so I was speaking really to that because she brought it up at a previous board meeting.
Okay, thank you.
It was indicated on the record that this was inapplicable.
All right, on the record. Okay, thank you. All right. You heard Ms. Woodland, another witness, Commissioner Woodland. She indicated that she had submitted challenges to petition signatures that she had collected for the Ward 8 special election. And she went on to indicate that she felt that the handling of those petitions was not, I'll say, they were not secure. Do you have any response to that, or is there something in her testimony that you would like to put on the record?
Absolutely. So, as far as any of her assertions that something was not handled properly, I would like to say that we take all allegations of impropriety seriously, as we are this matter. And so we are looking into it. We are investigating. We have asked Commissioner Woodland to provide the pages that she says she has, and she has not provided it. And so that is actually interfering with our process to conduct any sort of investigation if she has evidence that she is not sharing. To date, she has provided one page to us. And as you heard on the record, she is saying that 24 pages were removed. And so we do not have any evidence about that. But more disturbing is the fact that she has been very reckless with her comments about what she says happened without providing any evidence. She has posted numerous times on social media, calling our staff person out of her name, calling her, and I quote, stupid and dumb and should be fired, has tried to argue this in the court of public opinion, has put her address out in the public domain. And I feel that all of that activity is reckless. And if Commissioner Woodland is operating in good faith, and then she cooperates with the investigation instead of trying to undermine the investigation by trying to get information in the public atmosphere and stir the pot, if you will, and get people to reach out to us and comment about the actions or inaction of the Board of Elections without being transparent about the information we have requested and what she has not provided. And we have taken steps here at Board of Elections to address it. But as I mentioned, our investigation and our actions are significantly hindered if she does not cooperate.
All right. One of the things that Ms. Woodland did not provide to the committee, but she did indicate that she had documentation that was signed by the Board of Elections representatives indicating that the pages that she alleged gave to the board as challenge pages was accepted. She indicated clearly that they were signed and they were stamped by the board. And so in her testimony, she is saying that is her clear indication that these documents, that's what I call them because they're, each one is an affidavit. At least that's the way it reads and has read all the years that I participated in the election process in the city. So these documents are at least certified that she had them and she transmitted them and signed off by the board. Am I correct? Is that how the process works?
One of the things I would say is proper protocol was not followed. And as Ms. Commissioner Woodland stated, the documents were not counted before that information was signed. That is part of the process, that those documents are counted in front of her. She stated on the record that the staff person immediately took those documents and started scanning them. And so that was a departure from protocol, and we are investigating that departure from protocol fully. However, to also get to the issue of these pages and what was submitted, that's part of the investigation as well. So yes, she did receive a sign off on what she presented, but she also said that that was signed off without those pages being counted, which I have said, and I continue to say, was a departure from protocol, and fully accept responsibility for that. But as we continue to work through it and decide what action needs to be taken, we can't complete an investigation without having all of the information.
All right, so you're really informing us that while she is indicating she had 4 stacks of petition forms that she conveyed to a Board of Elections employee, that copies of those stacks were not made at the time that the Board of Elections signed off on having received those stacks of information?
Yes, we scan what we receive, and then she receives a link to that information. And she did receive the link of what we scanned.
But she did too also receive a paper with the signature or stamp from the Board of Elections.
That is
that
correct.
day. Is that correct?
That is correct.
Okay, and so the issue is that what she received maybe it wasn't counted, so there could have been a miscount perhaps?
We're trying to get to the bottom of the inconsistency. And so she has indicated she has a copy of what she submitted to us. We have asked for that, and that will help us resolve the problem. And she has refused to give that to us.
Well, I would ask her please to provide you with that. We have a copy of all the pages that she indicated she reviewed with, like coloring in it and highlighting pages 1 through 85, 1 through 58, 1 through 28, and 1 through 2. And those are the 4 sets that she received some sort of verification from the board that she had received.
Yes.
All right.
If I heard what she said earlier, she gave you copies of the actual petition sheets that were presented, and not copies of all of the challenge sheets. And it's the challenge sheets that are in question.
All right. Well, all I can tell you, Ms. Evans, is that I actually have something that says 1 through 85, 1 through 58, 1 through 28, and 1 through 2. They are petitions that say Trayon White, Ward 8, candidate's address, petition signatures in black and blue ink, signed by circulators. Accordingly, some have highlighted names. That's what I have. Okay. So I don't know what I have that she has submitted, but this is what she gave to us. And she said that she had documents at home. And
Yes,
so that's, I think, what we're trying to clear up. Those are the documents that you need in order
correct,
to verify what she is alleging,
correct,
correct?
correct.
Okay, thank you. Thank you so much. Sorry I had to go at it that way, but I just wanted to make sure that everyone's on the same page. Anytime we are alleging, when the public is alleging that an agency has not done its due diligence, hasn't done its work, we want to make sure that we're real clear with that.
Absolutely.
So thank you very much for that. I wanted to ask a little bit about the Ward 8 and election planning, and that is what outreach? I know that traditionally the board does some outreach in trying to get the word out about elections. So what has been done to get the word out about this special election?
Yes, well, as I mentioned, we have started outreach with Bureau of Corrections and Federal Bureau of Prisons as far as alerting the residents there that there will be a special election on the 15th of July. We have also started voter education and outreach events. In the month of April, we participated in 20 events on behalf of the agency, and they included mostly events in Ward 8. We have worked with citizen organizations. I even personally spoke at a town hall that was held in Ward 8 by Councilmember McDuffie. So we are making every effort. In addition, we will have a presence at Ward 8 Dems this coming Saturday, and the topic of that will be the special election as well. So our outreach efforts are very much focused on ensuring the residents of Ward 8 are fully aware of the election and the plans for the election.
All right, and how do you reach those voters that may be overseas or absentee voters?
We have a list of our UOCAVA voters, and we have information posted on our website, but we also ensure that ballots are mailed to them in accordance with our statutory deadline. So they will all receive a ballot, those who are Ward 8 residents.
All right, so does that mean that all Ward 8 registered voters will receive a ballot
That is correct.
by mail?
That is correct.
All right, okay, so we're,
Well, let me back up if I may. I will not say all registered voters will receive a ballot. I will say all registered voters will be mailed a ballot, because I had an instance where I did not receive my ballot, even though I have informed delivery and I know exactly what day my ballot was supposed to be delivered. So we mail a ballot to all registered voters, but I cannot speak to the affirmative that they will receive those ballots.
all right, thank you very much. Are you taking any special precaution as it relates to ensuring that only verified Ward 8 residents actually vote in this special election?
Yes, well, our equipment will be modified, and we're currently doing that as far as our poll pads, so that we have information that identifies those who are registered to vote in Ward 8. And so we will have only Ward 8 residents voting, and in the event someone shows up and their information is not available as a registered Ward 8 voter, we of course can take advantage of same-day registration, look up registration, and have the voter provide information that supports their residency so that they can cast a ballot.
All right, thank you very much for that. So how many, maybe you may have this number now that the petitioning process is closed, but how many different circulators did we have for the Ward A special election? Do you have that number?
Total number of petition circulators,
Uh-huh, yes, ma'am.
do not have that number. We can, because each candidate can have any number, so I don't have that number, but we can get it.
All right, would you please? And if we could get that in 10 days, I think we'll add to the record.
Absolutely. And just to be clear, you're not talking about any particular candidate. You're just saying for all candidates, how many?
Yes.
people? Okay, perfect.
All candidates, yes, yes.
Okay, and would that be for those who we deem to be eligible for ballot access, or everyone who turned in, because we did have some adverse determinations? And also people withdrew. So I just want to be clear that I understand the question.
I think of all of the candidates that you have verified for the ballot.
For the ballot.
Just,
Okay.
yes, just those that verified for the ballot. That
Okay,
would
thank
be
you.
helpful.
Thank you.
All right. And what does the board do when someone alleges that signatures were forged?
Well, they can file a challenge, and they do, but I'm going to actually let my registrar answer it more fully.
Thank you. Thank you, Chairperson Bonds, for that question. When there is a challenge that is accepted and is deemed, there are certain steps. First, somebody has to submit a challenge for it to be accepted. And once it meets those points, then we begin a review of any of the challenges for each individual signature that they've outlined in their overall challenge. So we go line by line for those challenges. And when it comes to a forgery, an alleged forgery, we compare the signature on the petition to the signatures that we have on file for that voter. We make a determination based on those comparisons.
All right. And how do you handle a situation where an individual's name and address appears on the ballot? I'm sorry, on the petition form, but they will call up and say, Board of Elections, I hear my name is on a petition. I did not sign it. Do they come in and take a look at what you have, or how is that matter handled?
So I haven't personally had that experience where I've had a voter reach out. There is a period wherein voters can submit essentially like a letter saying that they want to be removed from a petition. And I have experienced that. And so then we would remove that signature from the count of the petition. But I haven't actually had a voter, in my experience, say that they haven't signed a petition.
All right, that's really important because at our office we have heard a phone message that indicates that at least a individual said, I didn't sign a petition. Now, whether it's true or not, I don't know, but we heard that, and I was just very curious as to how does the board check for that situation? And what are the potential penalties for forging a signature? Do we have any standards for that yet?
So if there's a violation of the election law, the board can assess civil penalties and can make referrals for criminal prosecution.
Okay, is there, when you say civil penalties, is that a monetary amount?
Yes, that is a monetary amount.
Okay, can you share with us what that is, or is it on a case-by-case basis?
The board, I can fine up to $2,000 for a violation, a singular violation of an election law provision.
All right, for single, okay, violation.
Up to that amount.
Okay. So if you are a circulator or have been a circulator, and you've been found to violate or receive a civil penalty, can you, next election go round, circulate petitions again?
There is nothing in the statute that prevents that.
Okay. Thank you. So when a individual is challenging or wants to challenge petitions, what instruction do they get? How do they do that?
So when an individual wants to challenge petitions, we have information posted on our website that outlines the different processes. We have information on the different validity of signatures, depending on the petition type. We have different supplemental materials on our website too. Again, it differs depending on whether it's nominating petitions or ballot measure petitions. They'll be challenging.
All right. All right. And when is a challenger notified that their submission is not accepted by the Board of Elections?
Yeah, that's a great question. We try to do it within 24 hours of a submission. That kind of depends on, other things going on in the office. But in this particular instance with Commissioner Woodland's challenge, initially what we're doing, we're not doing a line by line review of the signature challenges. We're just counting to make sure, because one of the stipulations for us to accept a challenge, for it to be sufficient, is that it has to bring the candidate's signature numbers below the required amount. So that's why it's in other instances where Ms. Woodland has challenged candidates, she has alleged enough signatures to bring them below, so it moves, and then it does take longer to provide our findings on the specific individual challenges. But in this instance, within that 24 hours, we're just checking, and sometimes it's a quick count because they're smaller petitions, but this is obviously a larger petition. And so it takes time to go through the challenge to make sure that we have an accurate understanding of what the count is and if that will bring, the candidate below that required threshold.
Okay, and so you use Ms. Woodland as an example. So let's talk about what she says or alleges that she turned in to your staff. And she is indicating that she turned in 4 sets. So how many sets did you really receive? Not really, but how many sets do you indicate that you received?
Yeah, so we received 4 sets.
Okay.
2 of the sets, so the challenge that had 20, the challenge that was a challenge of 20, the petitions that contained 28 pages and that contained 2 pages, those numbers aligned. But the filing that was a challenge of the 85-page filing and the 58-page filing, that's where there were pages that were missing. And so, and there were, in one of them, there was actually 2 pages in the 58 page challenge set. There were 2 pages that were submitted twice. So page 40 and page 47 were submitted twice. So, you know, there were
Okay.
some discrepancies there.
All right. And so in the 1 to 28 page set, how many signatures was she submitting as being questionable?
Let me double check. I believe for the 28 set, I believe there were challenges to about just over 210 signatures.
All right.
110.
All right. And so that's the number of challenges within that group of pages, right?
Yeah.
Okay. And each page contained 15 signatures, 10?
No, it differs. There's up to 10 signature lines on a petition. For that number, it was around like, we had it, I think, at 257.
All right, up to 57. And so the other one where she only submitted 2 pages, how many signatures were challenged?
So between those 2 pages, the candidate submitted 10 signatures across those 2 pages, and all 10 were challenged.
All right, okay. 10 of 10. So 267 was the number of challenges, and the candidate submitted how many total signatures?
No, I'm sorry. So the candidate submitted 267 signatures, and the challenger between those 2 pages submitted 221 challenges.
So
Between the packets.
257 was submitted by the candidate.
In one packet, plus the 10 from the 2 page. So that's 267 signatures. And then there were 221 signatures that were challenged.
All right. Okay. All right. So the total number of petition signatures that were due was what? 500, 200, 100?
The required amount for this special election for a ward council seat was 500.
500. And so the candidate submitted 500 or more?
Over 1,500.
1,500.
Yes.
Okay.
Over.
Yep. All right. Oh, over 1,500. So therefore, when you give a candidate, I'm sorry, a challenger, the stamped information, is any of this presented to them? In other words, would the challenger know that, well, 1,500 signatures were submitted, and of the 1,500 signatures, your stack is showing, for instance, that there are 200 and you're challenging 210 signatures?
So when they drop off a challenge, we don't review line by line to make sure that there's enough challenges. That's why we should be doing a count of the pages that are received to make sure that we're in agreement. So on the document, I believe it's the receipt, that the number that's signed off on by both the challenger and the office is in alignment on how many pages are submitted. But we don't do a line by line review until after we've received everything.
All
like
right.
We don't do that first initial count of each line.
All right. And so it's my understanding from what Commissioner Woodland testified today is that she submitted 4 groups. And of the 4 groups, if we can do the simple math, we can see that it would be kind of impossible for, even with the other 2 sets that she alleges that she gave to staff, that she would have anywhere near knocking off more than 1,000+ signatures. And is that why she was called that day by Ms. Strode to indicate that she did not have enough for a challenge and therefore her challenge was not accepted?
So just to clarify, our process is that as the registrar, I send a letter that over email to the challenger on the email that they've provided us on their documents, stating if a challenge is not sufficient. And we list the different reasons. There could be different reasons why a challenge isn't sufficient. And so this reason was because with the documents that we had, we had 4 packets. Well, there were sheets that were, omitted, missing. With what we had in our presence, there weren't enough to bring the candidate below that 500 threshold. And when we asked for the sheets, again, we received 1, and that 1 additional sheet didn't bring the candidate below that required amount still. So, I sent that, I'm sorry, I should clarify. I sent the letter on the 30th. It wasn't May 1st. It was the 30th, the next day after the challenge period ended. And then in response, Commissioner Woodland shared that she had submitted all the sheets, and that's when we asked for anything that was missing. And we received the 1 sheet. So I believe the conversation, and I can let General Counsel Stroud speak to this, but I believe the conversation happened because Ms. Woodland was calling the office to try to figure out what was going on. And so I know that she had conversations with multiple staff members that day.
All right, well, I appreciate that. Ms. Stroud, she had indicated that you called her the same night, and I don't know whether that was the 30th of April or May 1, but that's what.
I don't remember the date, but she wanted me to call her. She didn't want to talk to anybody else at that
Okay.
because she wanted a different answer than the one that she was being provided with, and I could not give her a different answer. And what I recall from that conversation is that I said, it's the challenge is over because you've missed the deadline. We don't have the sheets. There was a mistake made by staff that indicated that you had submitted a sufficient number of signatures to challenge. And then throughout the course of our conversations, not just with me, but with other board staff, when we again asked for the copies of the missing sheets that she said that she had, she said that she was advised by counsel not to provide them, but that she would be providing them to the council, to you all, on sometime last week or, whenever. She was like, I'm going to go to the council on Monday with these sheets. So I was very surprised to hear today that she did not even have the batches that she claimed the sheets were missing from. I do find it very interesting that she said that she was not going to provide them to us, that she was going to provide them to you all, and that today she still has not provided the copies of those sheets. She did have the ones that, the copies of the sheets that she provided in full, meaning batches that had challenges to pages 1 through 28 and 1 through 2, but not the ones that had the omitted pages. I just find that interesting, and I'm going to leave it there. But the conversations were about what her options were. But again, repeated requests to provide the copies of the missing sheets, which she said that she had. And then there was an email that was subsequently submitted where she said she seemed to be abandoning her effort to have the board adjudicate the challenge because she said, even if I don't produce them, I think that there's still enough to bring him below, and you should accept these. You should accept what I submitted and use that to kick him off the ballot. So again, she seemed to be, retreating from that effort to say sheets were missing, but do something about this anyway. And so I said that, I sent her an email. Again, I don't remember the date, where I indicated to her that per the board's rules and regulations, the board could only adjudicate a properly filed challenge. And since we did not have enough challenges to proceed, and she refused to produce copies of the sheets that she claimed that she had, with the exception of one, the board had no jurisdiction to adjudicate the challenge.
All right, we will leave that as the last word on these petitions, and thank you very much for that. I think it's really important to clear up misunderstandings, and that is certainly what we're attempting to do today. I think, in fairness, I need to move rather quickly to the ANC questions, because you heard Mr. Bay's testimony, where he waits with bated breath to have the board to jump in and handle these ANC elections. Filling a vacancy is an election anytime people have to declare their candidacy and be placed on a ballot. I mean, so I wanted to hear from you, Ms. Evans, on how do we proceed? The Board of Elections is big in the world of the Office of ANC's Advisory Neighborhood Commissions.
Absolutely, and thank you. So the first comment I would like to make is, I find it disturbing when all of the allegations launched against the Board of Elections, they're all negative. We're unhelpful, burdensome, refused to investigate, did nothing, insulting, abusive. That's not helpful in getting us from point A to point B. And we are following a process. And you may not like the process, and I understand that, and I respect that, but attacking an agency like that, I feel, is inappropriate. I have not done that, and I'm not going to do that. But I just, wanted to say that I found that very disturbing and inappropriate. As far as having the board conduct all elections, we have over 300 ANCs, and we have, over 30 ANC vacancies at times. Right now, we currently have 16 ANC vacancies. I don't know what the proposal is, but to have us in election mode at all times does not give us an opportunity to reset. And so after every election, everyone always asks us, when does election planning start? Election planning for the next election cycle begins the day after the old election. So when we had the general election in November, that next day when all of the vendors are in town, we're meeting with them because we're discussing upgrades to equipment that has reached end of life. And so we needed an opportunity to get new equipment. We need staff to do that. I've been told, and it's been mentioned that, we're 24/7. That's what we do. We run elections, but we also have to assess what we're doing. We have logic and accuracy testing. We have to take equipment out of commission because it doesn't work in an election. When you're constantly in election mode and constantly asking your staff to work late nights and weekends, that is, I don't believe, the way we need to be structured. If we are going to assume that, then we really need a unit that addresses ANC elections. And that needs to be a separate unit with separate equipment and separate funding. As you know, we receive funding for the Ward 8 special election. There are a number of activities and things that happen in our oversight of election that cost money. And so I don't understand how people think that not giving us money, and this is just in the normal course of our duties, that we can take on the responsibility of over 30 additional special elections in a given year. So yes, we are Board of Elections. Yes, we conduct elections. But as far as the logistics, along with everything else we're required to do in preparation for an election cycle, which I don't think people fully understand. A lot of people think we're a plug and play operation. We show up with election machines, conduct an election, and go home. When you talk about the lotteries, when you're talking about the ballot proofing, when you're talking about programming machines, even you asked about how can we ensure that only Ward 8 residents are able to vote in the special election. We have to go through and program all of our voting equipment and our poll pads with the vendor to make everyone in wards 1 through 7 ineligible. And so that is a process. People need to understand the process before they make blanket statements telling us what we should do without understanding the full complement of everything that we do in preparation for an election.
Well, thank you very much for that statement. I appreciate that. And may I ask, what is the size of your staff? What is the Board of Elections FTEs?
65.
Okay. All right. Just one second.
And I will say while you're going through your notes, Council Member, we
Yes.
are more than happy to fulfill the responsibilities that are assigned to us. And as you know, when we are responsible for an election, it puts a lot of pressure and a lot of work on staff. Because when you think about a challenge period is 10 consecutive days. That challenge period includes weekends and holidays. So our staff members are working around the clock during those periods. When we get a petition dropped off, as we did with I-83, we have only very few days to go through and determine if the numbers are sufficient. And when that petition is dropped off right before the 4th of July, that means that my staff is required to work on the 4th of July. And so we don't have a choice about that. We don't complain about that. We do that. But I just wish that people really had an appreciation for the commitment level of staff and what we do. And I really wish people would not make reckless assertions, particularly on the record, without having a full understanding and appreciation of everything we do and the commitment and hard work of staff and the sacrifices that they currently make to ensure ballot access.
All right. Well, I thank you very much for your testimony. Your testimony has generated a number of questions, but I think given the hour, we are a little past 6 p.m. That your testimony has made it clear that we cannot serve the public today. But I must tell you, we will be serving the public, and we most likely will be serving the public through laws that will be generated by the District of Columbia. We have to, because this is a government of all of the people. And while I recognize much of what you said is true, we just want to make sure that those systems that handle this very precious opportunity that we have to elect representation, that it is that we have an effective and efficient way of going about it. And so it is in that vein that I believe the Office of ANCs presented their testimony, and it certainly was not in any way to cite or indicate a thought that the staff, the 65 members of the Board of Elections office were not diligent, don't care, or wanting to do everything that they can. I didn't read it that way, and so I'm hoping that that's not the intent.
Yes, and I do appreciate that, council member. And, I was just looking at the words, on their face. But, we always happy to look at processes and inform. And we, have often held, town hall meetings. People have reached out to us. I've had Zoom calls with members of the public who just wanted information. It's like, explain how this works to me. And I don't mind doing that. I wish more people would actually ask us how the process works, ask us what we do, ask us what's involved, ask us what's entailed before making assumptions about what we're doing, what we're not doing, or about what a law or a change will entail. Because without fully understanding, then I don't feel like we get to a happy endpoint with anything because you're making a decision that's not fully informed.
All right. Well, we want to talk with you later about Initiative Amendment Act of 2025 and get your feedback on it. It is moving forward in the council, and so is a couple of other items related to the work that would affect the work that you do. My wisdom tells me we've gone as far as we can on this, and I thank you so very much. I want to thank everyone who participated in today's roundtable for their contributions, including all of our public witnesses and, of course, our government witnesses. I'm glad we had the opportunity to discuss the preparation for the 2025 special election and the board's ongoing work with other matters. I look forward to continuing to collaborate with the board to ensure that district residents have access to the ballot. If the public has any additional thoughts or would like to submit written testimony regarding the performance of these agencies, please email it to CEAL at dccouncil.gov, and it will be included in the hearing record. The hearing record will close at 5:30 p.m. on Tuesday, the 27th of May. The next meeting of the Committee on Executive Administration and Labor will be a public hearing tomorrow, May 14th at 10 a.m. on the following bills. Bill 26-136, Special Election in the Office of Delegate Amendment Act of 2025, Bill 2643, Marion S. Berry Summer Youth Employment Program Creditable Service Benefit Amendment Act of 2025, Bill 26-182, Universal Paid Leave Portability Act of 2025, and Bill 26-185, Fair Hiring Opportunities for Public Employee Amendment Act of 2025, and is commonly referred to as HOPE, the HOPE Act. This concludes today's hearing, and with that, the time is now 8 minutes after the hour of 6 p.m. on the 13th of May, 2025, and the meeting is adjourned. And again, thank you to everyone who joined us. And if you have an opinion and you want to share it, please remember to send it in to us. Thank you again, and thanks to my team who joined me here on the dais and to the team in the support service